Lordship, sir. Additional Tahsildar has dictated the
Make use of mic. Your voice is bleak.
Hello. Lordship, additional Tahsildar has evicted the petitioner. It's a month of the puja. It is coming other categories of writ petition.
You want that matter to be posted tomorrow or next week?
Suitable to my lord.
Understood what you mean.
Tomorrow, Lordship.
What for it is? There is no clarity in speech.
Oh, speech. Lordship, this Tahsildar has evicted the petitioner. He is a month of the matter.
When it happened?
It happened 3 months before. Notice was issued to the boy. Thereafter, they filed counter. It is true.
3 months are over now.
No, this honorable court has was pleased to issue notice.
Yes.
Thereafter, they have filed notice next week. These are the CMPL Lordships against the FO and review. Lordship already has passed an order. Lordship has seen the courts.
But the petitions are almost
clear in
yes.
Clarity is important. Yes.
The petitions promotion has been stalled because of the pending of the DFS.
This is the academic matter. Academic matter regarding issuance of certificates. Matter is 2016. Matter it was listed.
Okay,
next.
This is regarding area salary matter, area remuneration.
Salary.
Salary matter.
Big often.
Pass the examination, but certificate not issued. Pass the examination, but certificate not issued.
Matter the petitioner has been working more than
Amendment.
more than 16 years of service. Matter the petitioner has been working more than 16 years of service. Regularization has not been done.
After 2 weeks.
The recruitment matter. Earlier, prior to vacation, it was allowed for next week. It was not come. Somehow it was not come. Second member.
Correction of certificate, my lord, plus to certificate. You are already directed to State Council to take instruction, my lord.
In that matter.
My lord.
Next.
Pardon the mention, this is identical matter, my lord. Your lordship directed to list this week, my lord. But then today it's not listed.
My lord, the auction of housing. After notice matter, my lord. Yeah, after notice matter, my lord. The auction of the housing board plot has been stayed, my lord, in the Hon'Ble court. It is likely, it was directed to list in the 8-9.
Now there is stay.
My lord.
The press addition 184.
One cohort matter. Coordinate bench has already decided that with regards to the area salary matter.
Arrears of salary.
Arrears, the coordinate bench order is there.
So after 2 weeks.
Next, one
press addition 184. Yes, 2025 184, my lord. FAO, my lord. Challenging the tribunal order, education tribunal order, my lord. One matter is RSP matter. RSP.
My RSCP matter,
Covered by judgment.
my university already part.
To academic matter, your lordship. Disputing your upcoming fee, your lordship.
Relating to establishment of university.
My lord. Of the year 2019. After notice matter, your lordship.
That's all. What is that? Academic is a very long, wide word.
The petitioner took admission in the Ayurvedic college.
Matter.
My lord.
Next.
2019, your lords. After notice matter.
2019 matter. Yes. Yes, sir. 2019, you know. Now, and one more festival is coming. We will celebrate festival and then we come out to the court with lights. Item number 1.
Lordship permission.
12, my lord.
Well,
Yes, my lord. I will take 2 weeks after. I will take some instruction of the year.
after 2 weeks. After 2 weeks you want?
Yes, ma'am.
2 weeks at the request now.
Always.
Can I make a mention? One of item 65.
65.
Yes, the opposite party, I have filed the counter and served the copy, but petitioner, he has filed a memo for withdrawal. That is also on call list, Manoj can
You want to withdraw?
No, I am not the petitioner. I am for the opposite party who has sought the copy, my lord.
Petitioner wants to withdraw.
Yes, that is.
Why he wants to? Is he not happy with the court or what? Why? No, I want to know. Many cases are withdrawn. That's not a heavy trend. Anyway, petitioner has moved a memo dated so and so. Dated 1/9/2025, seeking leave of the court to withdraw the petition. Although no reason is mentioned for seeking such leave. First, memo reads as a next. The counsel appearing for the other side does not have objection to the grant of leave. First, next.
I have also filed counter, my lord, by candidate technology.
Grant of leave. Although he points out that the counter is filed in the matter. Next, in the above circumstances, petition is disposed of as having been withdrawn in terms of memo.
Lordship, item 54.
Registry for whether they're served, other side is served. Registry to send a call. You are the only counsel on the other side.
Yes.
Yes,
Item 54.
54.
Yes, Your Lordship. The conducting counsel is having some difficulty for which is not available today. So I pray for next week, Your Lordship.
Be loud.
Lordship, the conducting counsel is not available today. He's having some difficulty. So I pray for next week, Your Lordship. Any day next week.
2023 matter, especially matter 3.
Yes, Your Lordship.
No. For 2023 matter, I have read the papers. I cannot read them again because they are not that beautiful. The script is not attractive in terms of law, nor in terms of language. No, I'm not giving time.
Yes, Your Lordship.
Really difficult?
Yes, Your Lordship. He is not available. So therefore, I'm praying for next week.
Arguing counsel is stated to be out of station. First, therefore, call this matter Tuesday.
My lord.
Tuesday, imminent.
Grateful friend.
Yes.
Item 1.
Yes. Both you have argued the matter so beautifully. I learned so much from both of you. Really. And the judgment is bit long. During vacation, I worked. I'm granting relief to them in this way. Just see. I have referred to Chicky on contract. I have referred to LIC of India versus Escorts Limited, 86 Supreme Court. I have referred to one judgment which you had read that is a GMR Varora Energy Limited, where a statutory contract was involved. I have referred to that one. And I have referred to one American court judgment also by Justice Oliver Wendell Holmes. I have dealt with the doctrine of estoppel because Mr. Begura very vociferously argued that. I have treated that. Then I have given the thumbnail sketch of Irrigation Act and the rules promulgated under the Irrigation Act. Then I have said as to how words in a contract should be construed. Because Mr. Behra said, unilaterally government can do, not at your instance. Very ingenious argument. Very beautifully he had argued that matter. So that also I have treated. And after treating this, in my considered view, it is like this. In the above circumstances, this petition succeeds. A writ of certiorari issues quashing the impugned order and demand notices. Matter is remitted to the portals of OP number 1 for fresh consideration in the light of following directions. This is important. The subject agreement shall be treated as comprising government water source and not irrigation works, both for the purpose of allocation of water and fixation of tariff. 2. The application of petitioner company for reduction of water allocation from 10.332 to 6 cubic of water to be allowed with effect from 3/8/2015 This quantity having been stated in company's letter dated 2/5/2017. In other letters, you have stated little more, little less. But in this letter, therefore, to be fair to both the sides, I have done that. The remanded matter to be decided within a period of 2 months, reckon from this day, after giving an opportunity of hearing to all the stakeholders. For any amount excessively charged and exacted from the petitioner shall be refunded with interest at the rate of 1% per mensem within 1 month, reckon from the decision on remand, failing which the delay shall carry additional interest of 1% per mensem, which may be recovered from the hearing officials. This way I have structured the operative portion of the order. If you have anything to say,
I think so.
that I will try to consider also. But one thing I should say, the way you argued, the way he argued, it really made me so happy. For long, I had not heard such arguments at all.
It's so great.
Very beautiful. I have praised both of you. For orally, I need not praise you again. I took more time. Generally, I do not take so much time, but the vacation intervened, holidays intervened. Yes, sir. Thank you. I will post it within a day or two. 1 day or two. Just I have to do some embroidery work.
May I please, Lordship?
Yes.
Petitioner retired inspector of school. Retired from
Notice retirement benefits to be dismissed. The G accepts notice for office. Which office? All office.
Yes.
All of this.
Matter lies in a narrow compass, post after 6 weeks. And in the meanwhile, the counter may be filed.
Okay.
Next.
Item 3.
Yes, ma'am. Yes, madam.
Managing committee resolution is there.
Yes, yes.
Actual 15.
Yes, my lord.
Issue notice. G accepts service. Any private party?
Private party is not there.
Notice to 4. Wait, 4 is there.
What is there?
Emergent notice to 4. 1, 2, and 3. G. Next.
Item 4.
Yes. May I please, Lordship, madam. The petitioner challenges the inaction of the opposite parties. By answer 1 matter is pending.
Short grievance of the petitioner is as to pendency of MC number 27 of 2024 on the file of Civil Judge Junior Division Raipur arising from CS number 7 of 2019 decided on 29/10/2019. First, learned counsel for the petitioner submits and this court agrees that right to speedy remedy being a constitutional guarantee in the light of a catena of decisions of the apex court, the court below has to make all endeavors to dispose of the subject MC at the earliest and in any event within 1 year, 10 months. Within 10 months. First year.
Within 3 months, man. Within 3 months. 3 months.
No. He will jump from the first floor. Which court is in the first floor?
Hostler, OP number 3. The hostler pending. This case is pending for OP number 3.
Within 6 months.
Within 3 months, man.
It will be very difficult.
3 months. Regular imports.
Petition disposed of according to all conditions having been kept over.
1 year is pending.
Registry to send a copy of this order. Not necessary. All you are representing all the respondents.
Yes, yes.
Okay. Go.
Item 5.
My lord,
Yes.
my lord, I have preferred this writ against the order of the appellate court, that is sub-collector Reda Court, and the division that has been
Release of gratuity.
Gratuity, etc.
G accepts, please follow, please. Any private party? There's emergent notice to 3.
Item 6.
The petitioner is a retired block grant teacher. Has bred
Hemant Chotra.
Hemant Chotra.
What judgment?
Similar
That is
cases
subjudice before the Honorable Division Bench.
one day posted. That case has been posted in one day.
You take
Batch of
let
cases.
us
It will better, yes.
accept these for rupees.
This is that added educational institution pension.
Emergent notice to form. Yes, call along with other connected matters. Do you have a connected matters number?
No, number.
Just see and just give them. Yes.
Item 7. Item 7.
Appointing as a Shiksha Sai.
Yes,
Similar matters we have considered and granted relief also. Take notice and make a note.
yes.
G accept for this.
Item 8.
May I please lordship? May I please your lordship? Similar order has been passed in wide annexure 13. Your lordship was pleased to pass a similar order.
Have you changed?
Yes, sir. Yes.
Give that.
Yes, some small change.
Judgment passed by
Yes.
your lordship.
Short budget. Next.
Please, published.
Item 9.
This is a matter of regulation for Ganashikha matter. Already.
He is claiming Balabhadra Maji's case, but the Supreme Court speaks otherwise.
No. Yes, but they have taken 2 years time to
Yes.
position. But the government regulation.
We have done similar matters.
Similar matter on the weekly listed that is some notice already issued, madam. Anyway, madam, batch of cases will along with. So that may be common.
Next.
Item 10.
Maybe.
Rejection is at annexure 6. Not should issue notice.
Yeah. He accepts for this. Next.
Item 11.
And in this case only the second round before your lordship, earlier my lord depends are pending and could go direct to the opposite party number 2, but without considering, so the prayer of the petition is annexure 3, my lord.
Increasing number of dates.
Yes, my lord. That means, my lord, one license holder having the 2,500, but without any, they reduced to the 1,000. For that reason, before your lordship, my lord.
What we have done in similar matters. In Karnataka, we have granted relief to the other side. Just accept Mr. Behura, take notice. Behura accepts notice for the office. Bring that Karnataka judgment.
Yes. I have option those website, my lord. Yes, I am trying, my lord.
Yes, next.
Item 13.
Please, your lordship. Lordship, the petitioner is a librarian, and though he is entitled to the revised scale of.
The scale is not given to him.
No.
In similar matters, we have directed consideration of the representation. We direct same way.
The
It is
representation
rejected.
already pending for the 1.5 years.
We direct them to consider Mr. Behura.
Annexure 14.
14. The short grievance of the petitioner as to non-consideration of his application for grant of UGC scales of pay of rupees 2,200-4,000 admissible to the post of librarian, correct?
Yes, my lord.
Right?
Yes, my lord.
Assistant librarian.
Assistant.
In terms of extant UGC regulations. First, learned counsel for the petitioner submits that though the representation was given on 27, what is that date?
27th.
Even you cannot read it.
1/2024.
Right? No, Annexure 14.
27/1/2024.
1/2024. So in this regard, and the sale has been kept pending without seeing all these things. First, he quotes Article 350 of the Constitution of India as has been extensively construed by various high courts in the country. Next, there will be on requesting for the OPs. Very fairly agrees that he would instruct his jurisdictional officials to look into the grievance of the petitioner as has been aired in the subject representation, a copy whereof avails at Annexure 14. He caveats that all contentions of the parties be open and a reasonable period be prescribed. In this proposal, counsel for the petitioner is agreed. Next part. In the above circumstances, petition is disposed of. Time for compliance is standard formats. It's open to solicit any information or document from the side of petitioner as required for due consideration. Next. Item 14.
But pursuant to Lordship's earlier order, my representation for modification of place of posting on promotion has been rejected. I have challenged.
You want a different place?
Yes, because 500 kilometers away, I have been and similar situation.
State is very broad, very wide. What to do?
They have modified so far as the 6% concerned. I have
they have not.
I have not.
Why they have been given that benefit and why that benefit is denied to you? What is the reason given?
The reason is that a threatening letter was issued by the director that unless you join in the place of posting on transfer, disciplinary proceedings shall be initiated against you. Either join or forgo. So I submitted application to forgo.
You joined?
No, I submitted application to forgo.
No.
So far as others are concerned, they remained 1 year on leave. The objective order of the director, they have been favored. The wrongdoers have been favored.
No.
And I obeyed, I have been discriminated.
That's all right. You have reported for duty.
Yes.
You have reported for duty at the place, 500 kilometers away.
No.
Then, see that what the law.
They have not also joined. They went.
That makes no sense. It is like one thief saying that other thieves have not been arrested. That does not help. In law is.
I agree to it.
Report for duty now. I will direct them to reconsider the subject.
No.
Report for the duty. Government has to work.
No, I have submitted application to forgo.
Ground for remaining away. That is what Varadha Rao says.
No, I cannot now join because I have submitted application to forgo. Unless the representation is
times now.
Unless the representation is accepted to act upon that promotion, as has been given to other 6%. I cannot join so moto because I myself had given the forgo application.
No, I will permit you now to join there, and then we will consider your representation, your petition. Otherwise, I am dismissing the petition.
I will oblige if your lordship will give permission to join there and make application for modification.
Correct.
And we shall be considered within
reasonable.
My lords, kindly see Annexure 9. Earlier, there was an order by this Honorable Court.
Pursuant to that order, rejection has been passed. That rejection order, I am challenging. That rejection is page.
Why for others you have allowed? For him, why are you saying why is stepmotherly attitude? If not 500 kilometers, 200 kilometers, 300 kilometers.
Where is rejection, madam?
Annexure 8, page 35.
Then
Annexure 8, page 8 of 2020-22. This order is of 2024, madam.
2024 order permission to liberty to withdraw the writ petition to file appraise along with that government has.
That was not the petitioner has made the following prayers. Prayers, come on. Is a representation of posting elsewhere having been negative. First one. Next person. Learned counsel appearing for the petitioner submits that here the leave may be granted to his going to withdraw the petition with liberty to make a fresh representation for working out his grievance. He also tells that if such a representation is made, the authorities have to take a call on that expeditiously and in any event within 2 months. First, the submission is fair. First, in the above circumstances, petition is disposed of as having been withdrawn with liberty as mentioned above. First, all contentions of the party that we have proven.
Lordship, permit me allowed to join in the place of posting.
No, why did you not join all these days?
Because it was from
Presentation. If they reject, you come back. We not that way. Because what all has happened if everything is away from the duty, the government should work. Yes.
No, I was continuing in the as the assistant teacher. I was not away from duty. The Lordship may direct to in keeping in view the.
Whatever you want to do, I have given liberty now. You have withdrawn the petition. I cannot give more orders on that. I can only permit you to withdraw. But I have made some observations so that comes.
Keeping in view Annexer 5, that
First of all, considering the representation in contemplation, the jurisdictional officials to keep in view the guideline. What is it? Guideline?
no, this is ordered in favor of other 6.
The order dated 28/2/2022, Annexer 5, which relates to arguably similar employees.
Okay.
Next.
Item 15.
My lord, this is a reader placement matter and covered by Chitaranjan Das versus State of Odisha and others.
Have you changed the other thing?
My lord, the prayer has to be quoted. So many
They are claiming relief after retirement. They are claiming relief after retirement. Can this be given?
Brother Satpat is the judgment.
They are claiming in these cases, they are claiming relief after years after retirement.
But even after retirement, I have granted relief to the employees.
My Lord, Supreme Court says otherwise.
Is it?
Because they are not holding the post, they cannot get the benefit.
Then you take notice.
My Lord, in some cases, appeal is pending now. My Lord, even if your Lordship disposed of, the appeal will be filed again.
They will take notice. Let him take notice. Well, what's your name, daughter?
my lord, my name is
The
Preeti.
daughter of a lawyer. Daughter of a lawyer, Mr. Chudi.
Yes, issue notice. Where accepts notice for notice. Any private party then?
No.
No private. Okay.
Item 16.
Revise the UGC scheme.
No.
Have they given any representation?
Yes,
They have
sir.
given Annexer 7.
7.
The short grievance of the petitioner is as to non-consideration of
Violence is similar to previous one.
correct. Which is the serial number?
It's 15.
15. No. Similar matter is disposed of, no? Non-consideration of representation dated 14. Right? 14. 14. 14. No, may not be.
No, just previous one is 15.
Retirements.
After retirement.
Similar.
Yes, sir.
They must judge from this. Call along with WP number. But they have given a representation which you could have considered this way or that way.
Your Lordship may.
Yes. The short grievance of the petitioner
Item 15
is non-consideration of the representation dated 10/2/2025. Where financial benefits have been sought to be extended in terms of policy and government norms obtaining in that. First one. The specific request of the petitioner is to extend the UGC scale of things. For the period between 53/1983, with effect from 15/3/1983 instead of 20 March 1986. First one. Learned counsel for the petitioner submits that if a direction is issued to consider the same in a time-bound way, comma, her claim would be satisfied. First one. With this proposal, learned PGA is agreeable provided all contentions of the parties are kept open and a reasonable period is prescribed for consideration. First one, this is fair and reasonable. Next one, in the above circumstances, petition is for of 8 weeks, solicit.
Then let's 15 also, your lordship.
Same also? Number 15 also, same one. But date you have to look at. 15 date is, date of representation is what?
That is
14/8/2000.
14/8/2025.
Next.
Item 17.
May I please, Your Lordship? Lordship, instruction was given to OP number 4 for inquiry and report, but the same has not been complied yet. Wide annexure 4.
That Directorate of Secondary Education has made the order.
Yes, sir.
My lords, this is PIL in nature.
Who are you?
Sir, I'm Tanuj Kumar Mishra.
No, that's not right. How you are related with this issue?
Petitioner, sir, I'm an activist. RBI.
You can be more active elsewhere. Why? How you concerned? You want to make money or what? How you are concerned with that? That inquiry will go on in its right pace. I'll impose cost. Unless you withdraw. If you want to withdraw, well and good. Otherwise, I'll impose cost of rupees 10,000 payable to Advocate Welfare Fund. We need fund also now. Who are you? How you are concerned with this? In service matters, no third party has no right at all, barring 3 exceptions, into which your case does not fall.
Sir, you not should pray for a week time.
Next time. But case is weak. You want to make it doubly weak? Call up to 2 weeks at the request.
Item 18.
Related to your salary, will matter already issue notice, madam.
Notice issued.
Yes, madam.
Issue notice, Mr. Benurag, please call this matter along with WP number.
Connector matter also same.
Same.
Data cases.
2 better.
Yes.
Yes, next.
Item 19.
19, my lord, also I am challenging the order of rejections. My lord, have already single matter issue notice.
Issue about then notice, Benurag, notice, call along with WP number such. Yes.
Item 20.
May I please, my lord? Here, my lord, the petitioner was appointed on 2/7/90 as a demonstrator, and petitioner number 2. Only the point of consideration, my lord, that similar employee of the institution, whose case was direction was given for consideration, but my case was rejected by the authority concerned.
Then let him take notice.
My lord.
Benurag.
Item 20.
20. Eta 20.
19.
19, both 2 matters are there similar. 19.
20 also same.
20, this is 20.
This is 20. All along with the 19, 20. Along with other connected matters.
Connected. 19 is connected.
19 is connected.
19 connected, I have given the numbers.
20 emergent notice, they were accepted. Yes.
Item 21.
Your Lordship, I challenge the order, the joining of MPhil of the respondent 1.
Who are you?
So I am also participating in that joining of the MPhil, and he has admitted that he is a scheduled caste. But annexure 2, it is issued by the Tahsildar that he is not a scheduled caste. And this is a fraud one.
No, who are you?
Sir, I am the one of the competitor by the respondent 1.
You also participated in the recruitment fray.
So he has joined as a scheduled caste, he has got the seat. And after that, he is joined in lecture.
Where is your
entire process is wrong, Your Honor.
Where is your certificate?
Sir, my certificate, I am the general. I am the general.
You are general.
General. But he has joined in MPL showing the scheduled caste certificate. But Annex 2 says that he is not a scheduled caste.
No, that's all right.
Not document.
That's all right. Suppose if he was not appointed, whether your case would have been considered against the vacancy? No.
Yes.
How?
He has joined as a scheduled caste, but in MPL, but he has joined in the regular lecture as a OBC. Obviously, he has joined in OBC in the service, but he has completed education in scheduled caste. It is quite a fraud system. We should stop the fraud system.
Go to the first item. Emergent notice. Okay.
Admit and issue notice.
Yes.
Item 22.
May I please, Your Lordship?
Yeah.
In this case, the batch of petition is pending before the Hon'Ble Court regarding count of past services rendered by the petitioner in non-government aided college when he joined in government aided college. In this case, notice was issued.
They are posted on which day?
They are posted in the year 2018, Lord.
No, connected matters.
It was posted to 11th August 25, man.
That did not reach that day, a division bench.
No,
single bench.
Which other bench? Before this court?
Yes.
Before this court.
Issue emergent notice, Mr. Lenka accepts notice forms.
This may be tagged into the main matter.
Call along with main, along with WP number.
Pleasure.
Item 23.
Yes, the petitioner has prayed, give a direction to the opposite parties to repair the main drain of Chaudhar and we give a direction to remove the encroachment and do the needful as the foul water is standing on my land up to 4 to 5 feet.
Which law gives that right to you?
I am the worst sufferer because the main drain has been encroached by some businessmen and some business establishment. The drain has changed its way and is flowing in the ward number 4, 6, 7, 8, 11 and 12. And water is dumping in my land at about 10 acres, 4 to 5 feet. As a result of which my agricultural land has been spoiled.
Where is your representation?
Our representation annexed to my lord. Page 31.
Consider representation, brother. The land is inundated now.
Yes, sir.
The short grievance of the petitioner is reflected in the representation dated 15 to 2023, a copy whereof avails and Annex 2. It is a legal notice. First, learned counsel for the petitioner submits that the officials being callous, are not taking any action in terms of the said representation, and therefore they should be directed to do their job. First, next one, Mr. Lenka appearing for the officials of the request
3, 4.
3 and 4.
And the 6.
3, 4, 6.
Yes.
Submits that he would instruct the clients to look into the grievance of the petitioner as has been aired in the subject representation in a time-bound way if all contentions are kept local. First, with this proposal, counsel for the petitioner is agreeable. Next one, in the above circumstances, petition is disposed of 8 weeks. All the petitions kept open. The party numbers, OP numbers, what we heard?
One more particular one, 1, 2, and 2.
OP numbers 1 and 2 to be heard before taking a call on the subject representation. Registry should send a copy of this order to OP numbers
1 and 2.
No. OP number 3. Why we can see OP number 5.
I think the councillor of that.
5 is Dilip Stabin.
The councillor of that.
Anyway, now he has made him a opponent. Therefore, let him be happy in the matter.
Yes.
Registry to send a copy of this order to OP number 5. Basically, 50 million. Okay. 5, 2 also.
2 is the chairperson of the municipality and the executive officer 1.
1, 2, and 5. Okay. Next.
Item 24. Item 24.
Representation on Annexure 7 is pending.
Can you explain to me when it's in a collectible language?
Yes, sir.
What is that representation? Annexure page 25?
Yes. His main grievance is that in his Titivan plot, his own plot, the work order has been issued for construction of a
building.
Yes. So that's why he has approached he has made representation to before the BDO. BDO Baki Dampada. And that is pending. No action has been taken.
In the representation, what is that? He wants what he wants.
He wants that the library is constructed over his own plot.
On his private property.
Yes.
He is against that.
Yes. The ଉପରୋକ୍ତ ବାକ୍ୟ ଦମ୍ପଡ଼ା ଦେଇ ଆମର ମୂଲ୍ୟବାନ ଘରବାଡ଼ି ଜାଗା ଉପରେ ଅଜାକରଣ ପାଠାଗାର କରନ୍ତି ଆମର ସାମ୍ବିଧାନିକ ସମ୍ପତ୍ତି ଅଧିକାର ପୂର୍ଣ୍ଣ ହେବ. Library is being constructed in his Stitibanpur.
In his land.
Yes. That is his allegation in the representation.
But just look into that representation.
Yes.
Private land cannot be used by the government without acquisition.
The Lordship may dispose of directly the video opposite party number.
The short grievance of the petitioner is as to non-consideration of his representation. What is that date?
Date is
in Orissa. Representation is a connection.
11/6/1925.
11/6/1925.
Next page.
A copy whereof avails a connector 7.
5. Annexure 5. Video is Annexure 5. And Tahsildar is Annexure 7.
First time. He has also made a similar representation to other ones. First time. Though counsel for the petitioner is absent when the matter is taken up, that would not come in the way of disposal of the petition, since the prayer is innocuous. First time. Learned counsel, Mr. Lenka, on request appearing for the OP numbers.
OP number?
All of this.
All of
the OPs.
Except 6.
Very fairly agrees with the suggestion of this court that OP number 6 should take a call on the subject representation, wherein a complaint is raised that petitioner's private property is being used for construction of a library building without acquisition process. First one. This is the petition. Next one. In the above circumstances, petition is disposed of. 8 weeks. Solicit, no cost. Next.
OP5, your lordship may say OP5.
OP5.
And order be sent to private party, opposite party 6.
Registry to send a copy of the order to OP number
6.
6. Next.
Item 25. May I pardon to make a mention in item note 16. Your lordship, your lordship, I will need to decide, direct the opposite party to dispose of my pending representation.
Yeah, we have disposed of now.
My lord, but may I pray, only my absence may not be.
Since may not really remove that absence. So you said no, though is absent, we said. Okay. Next.
Item 25.
25. Is refund of amount?
Yes, recovery. In such cases, your lordship has stayed.
We have in fact, Rafiq Masi, it is more or less Rafiq Masi, where we have said that consider the representation and in the if it fits into that one of the 5 parameters, then they have to pay back the money. But he is not here. Then everybody will remain absent on the ground that Dixit will give grant relief for you and we are absent.
Lakshmi ko password.
Password.
Yes.
All 1 minute matters. Yes.
May I please the court, your lordship? Your lordship, the petitioner here challenges the provisional order of attachment, which is at Annexure 1, your lordship.
Attachment by whom?
The Enforcement Directorate and PMLA, my lords. Your lords will see.
But you have that.
My lords, there is an adequate remedy which your lordship knows under Section 8. That is
correct.
But your lordship has also guided us with a recent judgment where your lordship has clarified that it is not to be used as a thumb rule or it cannot be a drug of choice. Now, my lords, why I say this? Because the litigation can be brought to an end here and here. Because, my lords, in Annexure 7, I'm sorry, my lords, in Annexure 9, they themselves have come back on their order and they have stated that because my properties were transferred before 2022, the same may be excluded from the order of attachment, the very authority who had attached my properties.
They have said that way?
Yes, my lords. That is exactly
it.
My lords.
Attachment order is made under Section
5.1, my lords.
And that is to be confirmed by
8.1. If they do not confirm, I also have an opportunity to approach the appellate authority, my lords. But they themselves have stated because the case was registered in the year 2023.
You take notice.
My lords.
Yes, receive the copy.
So you have discussed of
My lords.
The fact is, the provisional order of attachment has already been confirmed. Confirmed. And complaint petition has been filed also. So now the thing is that still remedies they are available under the statute. He is an outsider now. His property has been attached. He is claiming that his property has been attached. He is to satisfy to the Hon'Ble, that is a special court also. Because now the matter is pending with the special court after being confirmed. So as per provision of Section 8.7, special court has also power to decide the title of the property. If he has the title and it is not subject matter of the PML proceeding, it can, so there is a provision. You can approach there.
Read.
Yes. Well, first thing, now the provisional order of attachment under Section 8, a complaint is to file on behalf of the authority. It is to be confirmed after giving due opportunity. It has been confirmed now. Thereafter, my lord, Section 8.7 says, where the trial is under this Act, cannot be conducted by the reason of the death of the accused or the accused being declared as proclaimed offender or for any other reason or having commenced but would not be concluded, the special court shall on an application moved by the director or a person claiming to be entitled to possession of the property in respect of which an order has been passed under this subsection 3 of Section 8 pass appropriate order. So he is claiming that he is my property. I am entitled to the possession of the property. So he can make an application to the special court because the matter is pending now. And it has been already confirmed by the adjudicating authority.
Yeah, you have said that twice now. Now, but you only have said that he's showing some document where you have said his property need not be attached.
Where it will be placed, my lord?
Now, because now the proceeding is pending before the special court.
When did you say that?
No, that is an instruction.
Much before the order was passed. And your lordship, I just want to place.
No, why can't you put all these things, sir?
My lords, I will go, if required, I will go there, my lords. But as per my instructions, your lordship, I'll just quote a line, my lords. A man is not dead until he takes his last breath. The order has been resolved and it has not yet been passed. Unless an order has been passed, the order is not supposed to be deemed as confirmed.
Yes, sir.
The arguments were closed.
Dealing provision is
My lords, the arguments were closed. I'll just
So then I will produce the record.
My lords, by next week the order will come. What I need to clarify here, there is an interim order by this court not to proceed in the matter. They have violated that and they have gone through. I did not raise an objection because I allowed them to make that mistake.
I'll contempt. I don't know. This court, no order has been passed by this present proceeding. This is the first
same order. Your lordship will have a look.
It's there.
The order should have passed.
I'll contempt case also.
There's an interim order, my lords. I'll just show that.
In this case,
on the very same order, your lordship may have a look.
Then are you a party to that?
My lords, not exactly that.
What is that you are saying?
That is one, my lords. But the order has not been confirmed yet. There is still scope, your lordship. There is still scope. The order has not been confirmed and they have not issued.
Go before us. See, the extreme matters we can understand.
My lords.
What is that extreme urgency in matters like this? You can straightway go to that court, which section he has read.
Yes.
And I permit you to take up all contingencies which you have taken.
My lords, the order is yet to be passed.
No, the order should be passed. Read that section.
My lords. So they say that the trial 8 is exhausted.
Read that.
Where the trial is under this act cannot be conducted.
Yeah.
By reason of the death of the accused, or the accused being declared as a proclaimed offender, or for any other reason, or having commenced but could not be concluded, the special court shall on an application moved by the director or a person claiming to be entitled to possession. Yes. So now the thing is that if my learned friend is disputing that no confirmation order has been passed, I will produce it by the
lordship may note this submission that he is submitting that an order has been passed today, my lords. What I submit is still date right now, no such order has been passed. Only a provisional order is passed and the matter is still pending for consideration there.
That is so. We will go by your version now.
My lords.
Then section is attractive.
My lords.
You go there, direct the court.
Your lordship may say that they may not pass any orders without hearing me. That is the only thing which I am entitled to. If your lordship will observe that, what I'll do is I'll approach them and I'll place my point there. I will not lose one forum. Now, my lords, they themselves have come down and stated that my properties, I'll just complete, my properties are not under the provisional orders of attachment.
Yeah, in fact, I'm very proficient. I can claim my because I was ASC. I was appearing for PMLA throughout. And I have written quite a few judgments on that. Now my question, I have understood fully. The question is, you want your property to be safeguarded. That's your case. For that, remedy lies under section 7. I will permit you to go and explore the remedy.
My lords, your lordship may give that observation that did not pass any orders without hearing me. That is something I want your lordship so that
I can an application.
My lords.
They will hear you.
My lords. With that observation, your lordship.
The short grievance of the petitioner is that he probably could not have been roped into the precincts of PMLA Act by way of attachment or otherwise. First off. Learned CGC appearing for the OPs.
Retainer counsel.
Retainer counsel appearing for the OPs submits that the petitioner has got a statutory right to work out his remedy under the provisions of section 7 of the PMLA Act. 7?
8/7.
And therefore he should be relegated to the same. First, next one. Having heard that counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission of Mr. Retainer of the Retainer Counsel that petitioner can work out his remedy under the provisions of section 8 by moving an appropriate application before the jurisdiction designated court. Tribunal or court?
Designated court.
Designated court. First off. At the same time, that counsel for the petitioner is also justified that if such an application is moved, it should not be disposed of without giving an opportunity of hearing to his client. And that the said application should be directed to be disposed of expeditiously. First. Next one. in the above circumstances, petition is disposed of, reserving liberty to the petitioner to move appropriate application under Section 8 of the Act. 7. If such an application is moved, a call will be taken thereon within a period of 8 weeks. 7. Before taking a call, petitioner shall be heard in the matter through his counsel. First, all contentions of the parties are kept.
Gratefully, Lordship. Lordship, an urgent certified copy of it.
Today you will get that. Certified copy means a web post copy you will get that.
We gratefully, Lordship.
Web post copy to be acted upon.
Item 27.
My Lordship, I am on BC. My Lordship, let this matter come in next week.
Next week?
Yes, my Lordship. Yes, my Lordship. Yes, my Lordship. No.
Do you have objection for issuing notice?
No, my Lordship.
Not have objection. Well, thank you. Issue emergent notice, Lanka accept notice for the OPs. Emergent notice to 1, 2, 3, Lanka. Yes, next.
Yes. Your Lordship, item 28, Millards.
28.
Millards.
Yes.
Millards, in item 28, petitioner is an MTech student of opposite party number 5 institution and has passed.
Correction in what?
The correction in the provisional certificate. Because the provisional certificate that has been issued to me, there subject is missing in my second semester. There should have been 8 subjects, but it has been mentioned 7 subjects.
Who appears for the university?
Yeah, university is a private party, Millards. BPUT is the university which is conducting exam, and the institution GATE is a private institution, Millards.
But who should issue the certificate?
BPUT, Millards. University, Millards.
And next, sir, 4 years file a representation before the.
Correct, but they will not pass orders, they will trouble the students.
Millards, so 7 years.
The attitude of your universities, they don't do unless I hold them here. You take emergent notice. Let them come so that we can pressurize them to do it.
There are a panel of lawyers, ma'am. They cannot.
Patnaik was appearing.
No, Patnaik for university.
Issue emergent notice, Lanka for 1.
Campus step.
Well, that's what. Copy number 1.
Millards.
Copy number 1. Issue emergent notice to the rest, returnable within 2 weeks. First one. Pendency of the matter would not come in the way of considering petitioner's representation for correction of the certificate.
Millards.
Next, of course.
Web copy to be acted upon.
Grateful, Millards.
Yes.
Item 29.
My Lordship.
Yes.
Challenging the order passed by the collector from Chairman, my Lord. The Lordship admit the matter, issue notice.
Similar matter.
Similar matter, Lordship.
Notice. Project coordinator also you appear?
My Lord.
Yes.
Similar matter, Lordship passed there. And interim order there, my Lord.
Interim order is there?
My Lord. Earlier interim that should be contacted.
Counsel for the petitioner submits that. Next.
30. Item 30 regarding MSB matter. Similar matter already disposed of.
Take that. You have changed other thing?
Yes, we have already changed. 31.
Even may be submitted to place on behalf of Mr. Naik. The petitioner was appointed on 10/9/1991 as a peon of the school.
Antedating order of approval.
Antedating, what has happened was that they approved the appointment, Annexure 9, page 33, but without considering the judgment which was decided by the Honorable Appeals Court and the subsequent clarification of the Appeals Court. What has happened that 4 peons in the institution. One, and the Honorable Appeals Court has decided that you promote 1 peon from to the post of Daftari, being Daftari is a promotional post, and adjust the 4th person in the number 3rd. And that judgment was passed on 29th August 2003. They did not implement it, they implemented in 2012, my lord. And accordingly, benefit was extended. I was not given the salary, and Honorable Appeals Court subsequently clarified that they are entitled to get the benefit of salary 3 months after the judgment was passed, that is 29th of August 2003. That is the clarification subsequent.
Mr. Monty, you accept the notice.
Similar matter, my lord, disposed of.
Where disposed of?
Similar matter, but in that case, my lord, a representation was filed by the But I am not.
It is the question 91 and 2012.
91, my lord, the prayer of 91, I am not claiming.
You make a representation in terms of this judgment.
My lord, may I observe, my lord.
Petitioner's prayer reads as under. First, counsel for the petitioner cites decision of the apex court that in the state of Orissa versus Rajendra Kumar, thus 2003,
Volume 10, SCC 411.
10 SCC 411 in support of his case. First, next person, Mr. Mohanty submits that without making an appropriate representation, petitioner has rushed to the court in haste. Yes, and therefore petition should be dismissed. First, having said that, he very clearly submits that if the petitioner makes an appropriate representation, he would instruct his officials to look into the same in a time-bound way if all contentions are kept open. First, with this proposal, counsel for the petitioner is agreeable. First, in the above circumstances, petition is disposed of, reserving liberty to the petitioner to make appropriate representation within 2 weeks.
My lord.
And if one is made, which OP? OP number 3 shall take the call thereon within 8 weeks.
My lord.
First, all contentions of the parties are kept open. First, it hardly needs to be stated that subject the application in contemplation to be considered in the light of the apex court decision in Rajendra Kumar Das Supra.
A second also, my lord. State of Orissa versus Bhaktaranjan Dixit. State of Orissa versus Bhaktaranjan Dixit.
So this. Why he has come to my name?
Here, my lord, Hon'Ble.
Do you understand this? Fine, give it. 32. There is a saying in Sanskrit, I do not know, maybe by Kalidasa or Bhattravali, Ekanama Sadapriya. Same names. If we are having same names, there is a kind of natural affection. I feel. Yes.
In this case, petitioner was appointed as assistant teacher in a primary school. That is the elementary cadre.
Differentials of arrears of salary.
He is entitled to train scale on attaining 48 years of age, as per Rule 15(5) of the elementary cadre rule.
Any representation?
My lord.
Where is that?
Annexure 4.
Can I direct consideration of the representation?
Taking into account Rule 15(5) of the elementary cadre rule.
In the light of that.
My lord.
That is also annexed.
You have said that also, na? 1997 elementary cadre rule.
Yes, I have annexed the Annexure 2.
Yeah. No, that you have mentioned in your representation also. Let them consider in the light of Annexure 2.
My lord.
Perfect.
Annexure 4.
4. You are right. 2 is rule.
Yes. 2 is rule.
Yeah. The short grievance of the petitioner is reflected in the representation dated 10/7/2024. Kindly be seated. Listen to a copy whereof avails at an exact form. First, counsel for the petitioner draws attention of the court to the rule position at an exact 2, in terms of which the subject representation is required to be disposed of in a time-bound way. First, Mr. Mohanty, appearing for the OPs, very fairly agrees to instruct his which client? OP number 3 and 4. OP number 3 and 4. To look into the grievance of the petitioner as has been named in the subject representation. First up, he caveats that all contention should be kept open and a reasonable period be prescribed for disposal. First, next part, in the above circumstance, 8 weeks. All contentions kept open to solicit, no cause. No cause. 33. Yes, sir. I have no objection if both of you argue. Yes, but the dispute cannot be resolved by me. I can resolve the dispute of a litigant, not dispute between the lawyers. Yeah.
The petitioner appointed as a lecturer in Odia,
Lecturer in Orissa.
and in 2010, his post has been elevated to the first post because of the person who is holding that post is died. Died. Under Annexure 7, that is page 19. Thereafter, when his case has not been considered, he filed a GIA case, granting it before the tribunal, adjourned tribunal. That is a page 25, page 25, Annexure A. Yes, my lord, 24A. B. That is Annexure 9, page 25, 27 to 27. The relevant page 27.
What order?
That he sent to the directed the opposite party to consider the case of the petitioner in the light of the GIA order 2014.
They have not done that.
They have not done that. Against that also the principal of the college has sent the proposal under Annexure 11 in 31st August 2020 and 7/8/2023.
Why, brother, even when there is tribunal's order?
My lord, the tribunal's order, can I have a glance to page 27?
Yes.
They are claiming in 94, which has been repealed by that time.
No, but tribunal has made the order.
My lord, that in view of the foregoing paras, my lord, page 27. To consider the case in terms of the GIA 2014. My lord.
Kindly come to last paragraph.
Last paragraph. My lord. In view of the foregoing.
Just informal.
No, not that. Page 27. Thus, in view of the foregoing discussion, this OJ application is referred with the direction to the OP numbers 1 and 2 to consider the case of applicant in terms of granting aid order 2014. If he otherwise qualifies to hold such post within 4 months from the date of so you might have repealed that order.
Yes.
But as on the date he approached the tribunal, order was in operation. Unless the repeal says, this repeal is with effect from the first day. Otherwise, section 6 will apply.
Yes, ma'am. We'll file counter. Because we have to take instruction in that line. Because the Annexure 12 is there.
There is no reason for execution.
Because private party is there.
I have also
for execution.
Yes, I have also filed one execution case.
What happened to that?
That has not been.
I will direct the tribunal to process the execution in a time-bound way.
And before thereafter also they have rejected. Another person has been appointed in my post.
That's all right. But there is execution.
But there is execution.
The execution number?
4/24.
I will direct the tribunal to process the execution within 6 months in the light of which that decision, which is that where is our
Supreme Court decision. Rahul Sam.
Amicus curiae. Yes.
Rahul Shah.
Rahul Shah. No. Then after you said one more judgment.
Latest judgment appeals court.
Rahul Shah is 1 year. But the subsequent judgment is
Thereafter also time frame has been changed.
6 months.
It is 12 months to 6 months.
We will direct the tribunal to do that.
Well, private party is there, my lord.
No, I will send a copy of the order to them, and the private party also.
All the
can.
stakeholders.
Huh? You want me to send notice to private party?
Because they have been added as OP number 6.
Issue emergent notice. CG is requested to accept notice for 1, 2, 3, 4. Emergent notice 2, 586. Returnable within 2 weeks. First note. Next. There are private parties. They should be heard in the matter.
They should be heard because by virtue of the order of
file one more.
it is a prolonging notice.
Emergent notice.
Then they may be also given a notice to notice may be issued only in this case.
Yes.
If
This issue here.
Yes.
5 and 6.
5 emergent notice to 5 and 6. Yes. 34.
Appeal for my lord.
Yes.
Prayer for appointment under the rehabilitation assistance scheme, my lord. The application is pending before the higher authority. Unfortunately, the
18/24 rejection order is passed.
Well, that is at page 25.
my application is pending before the district education officer, my lord. The BO is rejected.
He is not the competent authority.
No.
My lord, kindly see the
Competent authority under the rules.
They are
Article
saying,
22, my lord.
they are saying DO, my lord, the BO has intimated is the same to the DO.
DO.
That is the communication made, not to the party concern, my lord. Page 25, my lord.
So it is not in the nature of order. It's an interdepartmental
Interdepartmental communication, my lord. That is under challenge, which is at page 25.
Generally, intradepartmental communications are not challenged. It is for them to look into.
My lord.
Unless some order follows from that. That's what courts have said.
That is to be asserted.
Rejected on the ground why he is not a...
He has not rejected. He has told it to the official.
To the official.
My lord.
Now, Mr. Monti, you will keep quiet with the departmental communication. Where should he go? I will direct the concerned person to take a call in the to dispose of the subject application. The district collector has to take
the DO.
District Education Officer.
This is a communication from BO to DO, district.
That is no
order. Exactly. So if at all DO will be directed, that can suffice that.
Petitioner has scripted his prayer as first. Counsel for the petitioner submits and this court agrees with that the BO could not have passed the order dated
18/12/2024.
1812 order number 2133 order, while memo number 2137 dated 18/12/2024. When the jurisdictional authority is the district education officer, Punjab, Brahmapur, Brahmapur, not Brahmapur. First. Learned AGA, Mr. Mohanty points out that is the subject order is in the nature of intra-departmental communication, and therefore it does not have trappings of the order in the light of apex court decision, which is that judgment. To say order means 74 Supreme Court, look into. E.P. Royappa versus Tamil Nadu. Can anybody assist? When what we call as order, there is judgment. No? E.P. Royappa. It does whatever it does. No, read again. It has trappings. It does not have trappings of honor, and therefore prayer cannot be granted. Just look into. I do not know. I don't remember. Go and bring my notes. Note O series notes. First. Chart. First. However, he further appreciably submits that the decision has to be taken by the DEO, regardless of the said intra-departmental communication, on merits of the matter. First, next one. In the above circumstances, petition is disposed of, directing OP number, DEO is what? 3. OP number 3. To take just find out the order. No. Brother, just look into, I have mentioned what is meant by order, etc. Yes. Take to decide the subject representation at annexer.
Annexer 6. Dated 31st January 2023.
No.
It is much before.
It cannot be.
Let them go for a fresh, my lord.
because it is a order of 24, my lord.
Most circumstances, petition is disposed of, reserving liberty to the petitioner to make an appropriate representation.
OP number 3.
And if one is made, the same shall be decided within 6 weeks. And result thereof shall be intimated to the petitioner as well. First of all, contentions in that regard are kept over. Go to O series. O. I did my notes when I was a lawyer, when we did not have all this facility 30 years ago. I wrote every word in a lexicography manner. Order means what? When whether an order kept in the drawer is an order or not. When it partakes the character of order. Order between X and Y, whether Z can challenge it, when he can challenge it. These things that we have done. There are the handwritten notes. My PS is to it that way.
Order means and ends. That is ILR 1993 Karnataka 2715 1000.
Just put the flag tag there. Yeah, next.
May I please, my lord?
Yes, sister.
My lord, the petitioner has had this case for a direction to the opposite part number 3 to release his increments and revise his pay. Which has been
reinstated.
Yes, my lord.
Is he reinstated?
Yes, my lord. And there are several judgments of this in court, my lord.
When reinstatement takes place,
The increments has to be paid. Even if departmental proceeding and criminal proceeding is pending. Here, departmental proceeding is pending, my lord.
it is pending.
Yes, my lord.
So not yet punished.
No, my lord.
Yes,
read the decision.
That to be the version of Samaraditya Pal. Other day we have argued that matter. No?
Yeah,
Do you have that copy?
Yes, ma'am. I'm given judgment, my lord. Division bench judgment also.
No, I have passed one more judgment in similar matters.
Rule 77 of Odisha Service Code also.
Where is your representation?
Annexure 17, my lord.
9 to 24.
Yes, my lord. 42, my lord, page 42.
Kindly be seated. The short grievance of the petitioner is reflected in the representation dated 9/2/2024, a copy whereof awaits at Annexure 17, wherein she has sought for sanctioning and payment of annual increments in terms of 7th pay matrix under OS or SP rules. First, counsel for the petitioner vehemently argues that pendency of disciplinary proceeding or a criminal proceeding is no ground for withholding of the increment. Mr. Monti, be seated. You can sit and think. She also tells that the standard authors of textbooks of service law, namely Justice Ramajai's Services under the State, and Mr. Samaraditya Pal, inwards law relating to public services, are of this field. First one. Next paragraph. Mr. Monti, do you have any submission? Merely because pendency, you cannot withhold.
On the ground of only pendency, this has been outing the.
Look at KGA appearing for the OPs, although initially opposed the petition, now agrees with the proposition of law.
Financial implications.
Yeah, increment means financial only, nothing else.
Increment by implication of financial.
First off, he also tells that the decision to be taken will have financial implications, and therefore matter should be left to the portals of the OPs, jurisdictional OPs. First off. Next up, having heard the counsel for the parties and having perused the petition papers, this court is inclined to grant indulgence in the matter to the effect that the subject representation of the petitioner should be considered, keeping in view the discussion of law as above. First, time for compliance is 6 weeks. All contentions of the parties are kept up. First, it is made clear that if the increments are withheld only on the ground of pendency of disciplinary proceedings or criminal proceedings, disciplinary inquiry or criminal proceedings,
Only departmental proceeding.
comma, that will be unjustifiable. Ordered accordingly, WP is postponed.
Oh, blessed.
36.
Please, your lordship.
Yeah.
In this case, petitioner was appointed as section teacher. When his post was not approved, he had approved this honorable court.
Arrears of salary.
Husband of the petitioner. Very my lord. Husband of the petitioner.
That's husband.
My lord.
He is not there now. From 27/5/2000 to 3/2/2011.
My lord.
Where is your representation?
Well, earlier, this is the sixth round litigation.
No, you want mandamus, na?
My lord.
Mandamus, to say mandamus, there should be demand and rejection.
Earlier they were rejected.
Where is that? Where is that rejection?
What happened in this case? He had earlier approved this honorable court, and this honorable court directed to approve the appointment of the petitioner with effect from 7/6/94. Thereafter, his service was approved. Thereafter, he was also terminated. His service was terminated. He approved the Leonard Sat, State Administrative Tribunal. State Administrative Tribunal reinstated. Quashed the termination order. Thereafter, therefore also he was not allowed to continue discharge duty. Thereafter, petitioner approved this honorable court in contempt.
Say something.
No, notice, because Annexer 7 is there. It is of 2011.
Issue emergent notice. Won't be accept notice for all of this. Since matter lies in the narrow compass, post it 2nd week of November. Or 3rd week of November. Yes.
Item 37.
37, may I please, your lordship? Your lordship, I may be pardoned, your lordship. I'm appearing online, your lordship. Item 37.
I will pardon you whenever you appear in person.
Your lordship, I have some personal difficulty, your lordship.
No issue. Recovery. Recovery is 41,348.
Yes, your lordship. Recovery from a retired officer, your lordship, and the prayer of the petitioner was for grant of the third RACP at the grade pay of 5,400. In fact, the petitioner had approached this honorable court by filing a writ petition, wherein a direction was given to consider the case of the petitioner. Thereafter, contempt was filed when the order was not complied, and in compliance to the order, your lordship, such order was passed, wherein a recovery was proposed to be made, your lordship, towards wrong pay fixation of the second RACP, your lordship. As per the Rafiq Masih judgment, so also office memorandum that the petitioner has already assailed before the authorities, your lordship, such excess payment cannot be recovered. Secondly, your lordship, a similarly placed person has also been granted third RACP at the grade pay of 5,400, which also the petitioner.
My lord, Annexer 6 at page 23. That notice home.
Yeah. Emergent notice. Mr. Mohanty accepts. Any interim application is moved? No.
Yes, your lordship, to stay the recovery, your lordship, which is proposed to be made.
Petitioner has sought for stay of recovery by moving the application supported by affidavit. First, counsel for the petitioner cites Rafiq Masih in support of the case. First, there is prima facie case made out for granting interim protection, similar protection having already been granted to several other similarly circumstanced litigants. in the above circumstances, application is pulled off. And OPs are directed not to enforce recovery order during the pendency of the petition.
My lord, notice and interim order of stay so far the recovery is concerned.
Yes.
Much obliged, Your Lordship. Item 38, Your Lordship.
Ask the summons.
Item 38.
38 is?
Item 38, Your Lordship, relates to the grant of the UGC grant of benefit, Your Lordship. Similar matters, a notice has been issued, Your Lordship.
Then it is?
In WPC number 21845 of 2025.
123, Mr. Monty, number 10 to 4. Call this WP, in this case, along with WP number?
21845 of 2025.
21845 of 2023.
25, Your Lordship. Obliged, Your Lordship.
Item 9.
May I please, Your Lordship?
Yes.
The petitioner grievance for regularization of service from Ganeshkar to Shiksha Sahayaka, Your Lordship. His service regulation was declined due to grant of non-approval of permission and during his service period to obtain the higher qualification, Your Lordship.
What similar matters, how the other judges have treated?
Your Lordship, can see the similar matters in the present case, Your Lordship, can see the annexure 12, Your Lordship. Earlier,
Balabhadra Maji.
Yes, ma'am. Balabhadra Maji is regarding to OTT, Odisha Teachers Eligible Test Qualification.
But that is not applicable to you, no?
No, my regulation was declined for non-approval of permission to obtain higher qualification during in service. I have been appointed with the 10th qualification. During in service, the government has directed to obtain the 12th qualification. I have obtained the 12th qualification in private. In that obtaining the 12th qualification, I have taken the leave which was approved by the headmaster. That leave was not approved when the regulation of service of other candidate was concerned. At that time, when the regulation of other candidates along with me, that OTT was not mandatory. But later the state has
subsequently it is made.
It is made.
But during that relevant period, it was not.
Not.
You take notice. Or if representation is considered to be
hard time, notice maybe.
Let notice go. So again and again, representation will not help you. Yes. Mr. Mohanty, examine.
Connected matter is summed.
Connected matter is?
Same.
Same.
Yes.
They call along with each other.
Item 40.
May I please?
Yes.
The petitioner my lord is working as a lady attendant.
I will hear you only after you give me the order of the Supreme Court. You give my High Court order.
Yes, yes.
Which is that Supreme Court.
Supreme Court, I have already.
Being in the court.
Month of August.
Yes, August.
The month of August, last week of August.
And your lordship dispose of one matter on my matter, relying that two judgments, Supreme Court, Rahul Sir, as well as that latest judgment.
Then only 12 months became 6 months.
And that is my lord, Pariyamal versus
Me. Not that. What is meant by order? That I know. What is meant by an order? There are about 3-4 judgments of the apex court. Anyway, what is this matter?
Here, the petitioner is working as a lady attendant since 1991. And in the meantime, he has already put more than 34 years of service. And he is in second now litigation. Just to kindly see Annexure 2. Annexure
notice. Let him notice. Go.
Yes, rejection order is there on Annexure 12.
Rejection is at Annexure 12.
After how many years you have rejected?
On the ground that they are not coming under the yardstick. So far this lady attendant is come. That is the sole ground on which ground the same has been rejected. That is the impugned order which is under challenge.
After 33 years, if you send the man out, when he should go?
Hands are tied.
He has to jump into Mahanadi.
The ground.
Along with the wife and children.
And the first round litigation, earlier writ petition,
The lady attendant does not come within the yardstick prescribed under the GIA.
there is already decision taken by the government since way back 2012, my lord, Annexure 5. Basing on that, National Court directed to consider.
Come back with a counter by that it will clarify because the improved order.
Only accepts notice for this. Stop.
Opinion number 5 is the governing body, not
Emergent notice to file. Can I revert within a minute or two? Yeah. Yes. Item 41.
Not here. I applied for certain certified copies. Certified copies. Under my lord, I am suffering from fever and cold.
You take some time.
No, my lord, here I am not all right. I'll come to court. I have to.
You can sit and argue also.
No, no. My lord, that is disrespect to the.
No, but when court itself says, there is no question.
My lord, I applied.
It is like volunteer non-fit injury. In your thought, law of thought, any standard book like Winfield, Bangia, Solomon on thought also, there is one very famous book. All they discuss volunteer non-fit injury. Is it?
My lord, under the Orissa Right to Public Service Manual, that is an act prescribed by the state government, I applied for some certified copies.
They have to provide certified.
They did not provide certified copies.
Or certified copy of what?
My lord, certified copies of.
Annexure 192.
Yes, my lord. My lord, that is the documents which I wanted of a criminal proceeding which was ended in 144 and 145 proceeding. Then I preferred an appeal before the collector. That is under Annexure 2, my lord. The appellate court, your lordship may kindly turn to page 8.
Under the above circumstances, collector.
The sub-collector Balangi office record to sub-collector is directed to supply certified copies of the record sought for. But in spite of this order, having not challenged this order, yes, my lord, they are not even providing me the certified copies.
Why, brother?
What reason they have not?
You accept notice and call this matter on Monday, Tuesday. Why he is not giving? There is something. He wants copies.
Yes, my lord.
Copy, if he were to ask, you could have said, no, no copy. Copy you have to. After all, the whole world is moving towards transparency. What is there? What is that secrecy?
No secrecy.
Perhaps he wants something.
No, the record only, my lord, the appears the record
notice for 1, 2, 3. First off, it's a matter lies in a very narrow compass. First off, call this matter on Tuesday, instant, immediately.
Grateful.
Yes. Get well fast.
Yes, ma'am.
42.
May I please, Lordship, the prayer of the petitioner is the grant of notional increment with effect from 1/6/1994, Your Lordship.
1/6/94?
Yes, Lordship. Where, Your Lordship, kindly have a glance to the Annexure 2. Where the similar school which
have given.
Your Lordship, kindly have a glance to the Annexure 2, page number 17.
17.
Page number, Your Lordship,
not 17.
The 10 Girls High School, Your Lordship, Annexure 2, the Director of Secondary Education, letter, Your Lordship, 58026, letter 23/11/2007, Your Lordship.
Where is your representation?
Representation, Your Lordship, under Annexure 10 series, Your Lordship.
Page 27.
Page 27.
Consider that.
Yes, but taking into account, Your Lordship, Annexure 2 and 6.
2 and 6.
Yes, Your Lordship.
Short grievance of the petitioner is as to non-consideration of his representation at Annexure 10 series, wherein he has sought for, she has sought for, is it not?
Yes, Lordship.
She has sought for notional increments with retrospective effect from 1/6/1994. First, counsel for the petitioner submits that there is a stony silence from the side of MPs and therefore indulgence of this court is highly warranted. First, learned ASC appearing for the OP submits that if a reasonable time is granted, he would instruct the OP number 2 to take a call on the subject representation. First, he enters a caveat that all contentions of the party should be kept to. First, with this proposal, counsel for the petitioner is agreeable. Next, 8 weeks. Solicit. No course. Okay.
Taking into account Annexure 2. Taking into account Annexure 216.
The consideration has to happen keeping in view the documents at Annexures 2 and 6.
Grateful.
Item 43.
Well, in this matter, my lord, the petitioner has approached this honorable court for granting his script. And this court has directed to consider for representation. But under Annex 8, the authority
They have rejected.
Yes, ma'am.
Basic substance. Item 44.
I am on behalf of my senior.
Are you? For you.
Mr. Lingaraj Sodangi. And is somebody another court making submission.
Open the file.
Sir, Lordship.
Just open the file. Let us see what you have kept. I want to see whether you have kept something rasgulla or something inside.
Lordship, honestly.
You are to open that file.
Lordship,
I will not eat away.
Lordship, to be honest, he is the file is with him. And sir, pass it over after launch, Lordship. Pardon.
Commercial court order. All right. Post lunch. Post lunch means after lunch.
Item 45.
The petitioner is not aggrieved by election of the opposite party number 5 Millard as executive member of Khurda District Chemist and Druggist Association.
Election to be set aside. Election to be set aside.
My lord.
How can they?
But here I'm not concerned with the passing of not here, Lord. You also will find, Lord, this election to association, Lord. This is zone wise, Lord. Each police station is a zone, Lord.
Which police station zone it comes you want to?
My lord, that I don't know, Lord.
You very short prayer. You telephone your officer and ask within which police zone it comes. That's the prayer.
My lord, you also can also dispose of directing them to.
Why directing? I will get that number.
My lord.
What is this? You want your 2 goats back? Is it not? Why on that thesis?
Yes,
ask at 2 I will call. Telephone concerned officer, your commissioner, who is that? Commissioner of police or what? Or Cuttack, which is this place?
That's
Bhubaneswar. Ask your commissioner of police in which police station limit this particular shop comes. What you are going to do with that information?
But that opposite party number 5, Lord, he has been elected saying that he belongs to Capital Police Station, Lord.
Whether that geography is also relevant. Constituency.
Police station wise zone, Lord. Each zone.
Short grievance of the petitioner is scripted in the prayer as under. First. Counsel for the petitioner, a bit in variance with the scripted prayer, submits that his client would be satisfied if OP number 1 clarifies about the exact police station within whose jurisdictional limits the medicine store of OP number 5 he is situate. He is being run.
Your Lakshmi clarify Messrs. Akhandala Medicine Store.
OP number 5. We have said that.
OP number 5 is the proprietor of that medicine store. So it will be better. Messrs.
What full name?
Medicine store. He is the proprietor of that medicine store.
Who jurisdiction? What you have done?
Akhandalamani
Medicine store.
Bhavani Ashok apartment.
Is situate. First.
You must make a
Next paragraph.
that Bhavani Ashok apartment, Ganganagar, unit 6. Irrelevant.
Full details are furnished in the cost title as OP number. Next paragraph. Learned ASC appearing for the OP submits that he has absolutely no objection for furnishing the information. First.
Except
Next paragraph. In view of the above, OP number 1 is petition is disposed of, directing OP number 1 to furnish the information to the petitioner within 24 hours. The information. One fun.
Additional Chief Secretary government. It can be provided by the DCP itself or the concerned IAS.
We are telling your government, whoever wants to tell, what is for this time? Within 48 hours. Within 48 hours. And report to the Registrar General of this court. What is this? He wants information, even that also. Yes. See, for what kind of cases, reliefs, the people are coming to court. We don't understand. Because he wants this information to challenge the election on the ground that he does not help that constituency.
Disposed of.
Yes, disposed of. Within 48 hours, they should furnish and report it to the Registrar General of our High Court. Because he may play, other persons may do something. Register and copy of the order to the private, any private OP is there.
Private is the election officer opposite no 4.
OP number 4. 4 and 5.
5 is the he is elected. He is elected.
Order 2, 4 and OP 4 and. We do not know what.
Yes, 4 and 5.
Next.
May I please your lordship on behalf of Mr. Devendranath Mishra Mayor, the matter relating to the petitioner claiming UGC scale up pay.
Ordered by judgment.
My lord.
But other matters are posted on which date?
The dispose of my lord.
Dispose of. Your date and other things you change it.
My lord.
Amarendra Naik.
Simon. Samarendra Naik.
Yes.
47.
The applicant is married daughter miller and she has applied on the rehabilitation scheme after death of her father miller. And he's applied the rehabilitation scheme in late. So the government has make a list, those who are submitted their application at a belated stage. So their application, there are 21 persons, they make a chat and they have sent it to the district inspector, director of education and elementary education to consider that those 21 cases. That is under annexure 6.
What? 6.
Page 41.
Your name does not figure?
My name is there on serial number 5.
Your name is there?
42 page.
42 page, serial number 5, Karnalata Das. Late application, the applicant is a married person and submitted affidavits from Executive Magistrate Jagatsinghpur, wherein it is mentioned that she is still maintaining a look after her widow mother. So that application, that list is pending before the Director of Secondary Education, Odisha Bhubaneswar. Meanwhile, under annexure 2, my lord.
But your client is a married person.
Married.
What husband is doing?
Husband is not doing anything.
Why did you?
If some landed property, agricultural land is there, she's, that her husband is looking after the family.
But how much land he has got?
3 to 4 acres.
Very, very restricted.
I have not studied anything.
Then how can you enter the box here and cross-examine you? Whatever is not stated, you are not supposed to answer.
No.
Unless you agree for being cross-examined by the court.
And I am not sorry. Thereafter in annexure 2, my lord, they have rejected my application on the ground that I am the married daughter.
You are?
Married daughter of the late.
Suppose your client is married to a person from Tata family. You mean to say after father's death, she will be entitled to compassion? Simple. For whom compassion? Compassion is to those who are in difficulty.
She's the mother is a widow and nobody is looking after her. She's looking after husband.
Husband has got property.
His husband has got property. But the mother is even go to another family. It is not in his own family. So why his husband will look after family? And in this connection, the Orissa High Court decision is there, my lord.
Even
married daughter have to.
Let us. It all depends on many factors, not single factor. Yeah. Okay. Notice. All the week. All. Okay.
48. Employees of an education institution, my lord. The pay revision was made in 2017, effective from 1/1/2006.
2/39/2017. Your claim is?
Yes, madam. They have from pay revision was made from 1/1/2006. But they extended the benefit from 39/2017.
It should be 1/1/2006.
That is true. I am in paragraph 8.
But regulation says other date.
Yes, ma'am. I have given to this matter already decided. Issue settled, my lord. In paragraph 8, page 4, I have given the judgment. In two judgments,
no decision is taken in this one.
In this one, no decision.
Resolution has to be considered, no?
Yes, ma'am.
Will issue notice.
Yes, ma'am.
Any other alternative?
Notice is short that.
Yeah. Yes, accepts notice. Matter lies in a narrow compass. Post it in second will come. Third will come now. Okay.
Item 49. Here is the order of transfer. I am challenging the past at the recommendation of the MP and MLA.
Similar order.
Yes. Notice issued and you also complaint. Also connect the matter to the other matter.
Guideline में official provision is there मतलब. National guidelines in page 30 of the guideline में. Para 6. Para 6 of the guideline में page 30. Appeal and review मतलब. We have passed an order saying that file appeal.
But Annexure 5, this is the Annexure 4 is the guideline. But deviating the guideline, they have issued the government instruction empowering authorizing the MP and MLA to recommend 15 names. That will also already issue notice and
it's all right. You can file appeal also.
Appeal I can also file.
But I will protect you for or will call along with the
yes, better. Same.
Yes, it works up notice. Otherwise, your client will ask. For them, the other lawyer got the order and you are not in a position to get the order.
No, other matters, they are also Karnataka High Court has passed this judgment.
Justice Pandit
and I am also division that is on a different footing. That is a
division bench.
Yes, that is a complaint was raised against the before the MLA and MLA recommended for transfer of that employee. Here is no complaint.
Okay.
May I please?
Item 50. Yes.
Petitioner has challenged the transferring of the petitioner by the DEO, my lord.
DEO transferred him?
My lord.
From which place to which place and what is the distance?
My lord, the difficulty is, my lord, I am appointed as a BLO, Group Level Officer, for the SAR, my lords, by the election commission, my lord. Chief Electoral Officer, Bhubaneswar, my lord, for special intensive revision, my lord.
Revision of electoral roll.
Electoral roll. Well, I have selected and I was undergone, my lord.
Not case of transfer.
My lord, I have, despite, my lord, I have been appointed as a BLO, my lord, and violating their own guidelines, they have transferred. Your lordship can have gone to page 14, 1-4.
1-4.
My lord.
What it is?
Serial number 43, my name, my lord. And your lordship, last paragraph, as per the letter number such and such dated 18/8/2025 of the School and Mass Education Department, Bhubaneswar. Letter number 4068 dated 13/8/2000 of the Chief Electoral Officer, Orissa Election Department. The teachers appointed as BLO shall not be relieved until the process of revision of rules are concluded.
What is meant by that?
My lord, sir, if a teacher was appointed as a BLO, my lord, he shall not be transferred, my lord, during that process, my lord.
It's under section 28 capital A of the RP Act. Give that representation of people. Take out that judgment, district election officer versus so and so 2012 ILR Karnataka DB. Justice Kumar right there. It's a man Kumar right there. Does not amount to transfer. Give representation of people at 1951. Take out section 28 capital A. Give them. There are two statutes, 1950 Act and 1951 Act with the same name. It kept the returning officer filling out the record in the deputation to special person case with certain election, the filling officer. Take out that judgment, district election officer versus so and so 2012 or 13 so ILR. Will you look into it? Come back. Yes. Tomorrow.
Yes.
There's a division bench judgment.
May know the
district election officer versus
district.
So and so. Is there? I had argued.
In this case, my lord,
State of Karnataka.
In this case, my lord.
Yeah. So read that and come back. That may finish. District election officer versus State of Karnataka. District election officer versus State of Karnataka, or Election Commission of India versus State of Karnataka. Justice M.N. Kumar judgment. You one more. Except that it will go to them. M.N. Kumar. Just look into that. It's there. Give that one. ILR 19, AR 19, sorry, AR 2012 or ILR 2012, whichever in both. Yes. Come on. Item 51.
51. May I please, Lordship? The present petitioner was a victim of a road accident and he filed a motor accident claim case hearing number 54 of 2020 in the court of the Third MSCT from Additional District and Session Judge Jagatsinghpur. And when the matter was pending, the engaged advocate Sri Kailash Chandra Parida passed away on 10th March 2025. And the petitioner did not engage any other advocate, my lord.
Yeah.
But the opposite party insurance company, at their behest, the matter was placed before the National Lok Adalat on 10th May 2025. And a compromise petition was filed that the matter is settled between the petitioner and the insurance company for an award of 1,25,000. And in that compromise, the opinion of the present OP number 3, one advocate is Sanjay Kumar Parida. He unauthorizedly represented and signed in the compromise petition for the petitioner. And an award of only rupees 1,25,000 was passed by the Lord and Tribunal, whereas the petitioner had claimed an amount of rupees 25 lakhs in the claim petition.
25 lakhs?
25 lakhs. He had claimed 25 lakhs. He was not represented.
What was the, for that, making that claim, what is the injury or death? What is that case about?
Injury, the severe injury. He was quite invalid.
How many days he was in the hospital?
For some months, my lord.
Give that information.
My lord, here the case is that there is a fraud on court.
Now, decide. All circumstances have to be looked into. Is it not? Fraud is to be established by circumstantial evidence.
No, it is clear, my lord, that the advocate for the petitioner passed out. And he had not engaged the advocate OP number 3, present OP number 3. He had no ability to represent the petitioner and sign the compromise petitioner on behalf of the petitioner.
All right. Whether that advocate died twice?
My lord?
Only once he died.
He died on 10th March.
But you are making it thrice now.
25. And the award was passed on, my lord, 10th May 2025.
That's all right. It is a case of injury. You can claim 25 crore also because there is no court fee, nothing on that. It is only 50 rupees or 10 rupees, I do not know. Therefore,
what is payable, normally it is paid after getting the...
Before disbursement of that award.
For injury, you have to answer first how many days he was hospitalized. I want to know that. I will not issue notice against the lawyers easily unless there is a prima facie case made. Suppose if I issue another 10 years and your client will go on showing it, no, their case is pending against this lawyer. What about his career, his livelihood? We do not know. Therefore, on the basic question.
My lord, I am questioning and challenging the impugned order of the Lord and Tribunal, my lord.
That for saying
Tribunal has not taken care of the case, that the petitioner is not representing the case. Somebody else unauthorizedly representing on behalf of the petitioner. That should have been taken care of by the Lord and Tribunal.
You are not answering the question.
My lord.
You want the case to be dismissed.
My lord, I may be given an opportunity if your lord is directing me to submit the dates for which the petitioner was hospitalized. I will be submitting it.
Produce injury certificate and hospitalization certificate and treatment prescriptions on the next date of hearing, failing which petition runs the risk of dismissal. Suppose if I issue an order admitting this, it will be kept pending. What about that lawyer? To everybody, a case is filed against him, fraud and other things. Don't go to him. Many things may happen. We do not know. His livelihood may be depending upon law itself. Yeah. All this matter in the second week of November. Yes.
Item 52.
52 ballot orders requisite I will file by Monday, but a small correction, inadvertent mistake. That is 20,930 of 2025 is the number of the WBC.
Correct.
That was typed as 20,903. Instead of 20,903, it should be 20,930. Let it be corrected.
Registry to rectify the number of the petition and permit the petitioner to furnish the requisites within 1 month.
Item 53.
Requisite already filed on 9/9/2025, my lord.
Requisites are stated to have been furnished on 9/9. Registry to look in. Next. You can go and show it to the registry itself. Yes.
Item 54 has been adjourned, sir. Item 55.
Yes, sir.
My lord, in this writ petition, I challenge the order dated 16/1/2024 passed by under Annexure 8.
Yes.
That I am a retired person. Now the government, now the OP number OP number 5 and OP number 6 has given a proposal to deduct amounting of rupees 54,000 something from my gratuity, which is illegal and for which I have filed a writ. In that,
consider, you make a representation and consider. That was the order.
Correct. So that I challenge that order, stating that without the issue of prior notice, how they propose to deduct the rupees from my gratuity without any intimation to me.
Yes, who appears to Mr.
My lords, in fact, the order was challenged earlier.
Same order?
Yes, my lord. And it was dismissed.
It was not dismissed, but it was directed to constitute.
No, after consideration, again,
they have rejected. They have
my lord, kindly turn to my counter. Para 6.
Para 6.
Well,
before the tribunal?
Well,
Where are those orders? Where are the orders? OA number 1080 of 94?
Yes, my dear.
which post he was holding, Mr. Behura?
My lord, teacher, assistant teacher.
Assistant teacher. Have you given the salary admissible to the post?
My lord.
Now your grievance is deduction.
My lord.
Deduction.
My lord.
My lord.
Deduction from DCRG.
I want to know right now, without any intimation to the petitioner, how they are deduct the amount from his gratuity. These are the judgments.
Nothing can be deducted from gratuity.
My lord. Without any intimation.
My lord's WPC number 13587 of 2016, where the order of tribunal was challenged.
That was related to pay scale.
That is, my lord's fault.
My lord.
Sometimes he was on deputation. And by interim murder, he was paid a higher salary. On refixation, actually is not entitled to TGT, trained graduate. He has no qualification. He has no qualification.
How he has deputed to a Sanskrit Pandit? How? If he has no qualification. It is not the matter. The matter is that as to why they have deducted the amount from the gratuity after his retirement.
My lord's refixation was challenged by the petitioner in the tribunal, my lords. And the tribunal dismissed the application. And again, it was carried to this honorable court by way of writ petition. And that order was not given in this writ petition, my lords.
My lord,
there was a suppression, my lord.
Suppression, there is no question of suppression. Only I am challenging the order under annexuring. How you are daring to deduct the amount from his gratuity without the prior notice.
No, that's all right. The question is not that.
The question is,
they had given a particular pay scale higher than the one admissible to your post regarding as to your qualification.
Yes.
Number one.
Then the refixation, not my lord, that. My question is how we are deducted the amount from the gratuity without his intimation.
No, suppose now if intimation is given to you.
What will file the show cause? Without any show cause, you will do anything.
No, you have lost a case.
My lord, I have passed on, sir.
No, that's all right. I look into that also. But the point is, you were challenged to refixation.
I am not challenging the refixation.
No, you were challenged it earlier.
Earlier, my lord.
You lost it.
Previously.
You lost
that
it.
Matter is now not connected with this matter. My question is how to deduct the amount from his gratuity without any intimation. It is they do. आपको देखिए मत देखिए आप लोग मत देखिए.
No, that's not it. This is correct position of law. We don't dispute that. Now what Mr. Behura is saying is...
My lord, he has told everything. But the question is how to deduct the amount. He is now retired from his service.
You notice
without notice. How we are there?
You give in the light of Maneka Gandhi, post-decisional hearing.
Yes.
Now already you have deducted, na? You give notice and hear him, Mr. Behura. Then suppose he gives explanation.
43.
Then you have to return the money. If his explanation is not proper, then he has to come before the court.
My lord.
But my lord, what I humbly submit, my lord.
This is settled in the earlier round of litigation.
It is residuicata, this cannot challenge it. It will go on like this one.
Sir, apart from your question, I have also a question. If you permit, I will ask that. You had challenged the refixation of salary. It's a different thing, I know.
I know that is a different thing.
I know, therefore I am telling you.
I have not raised any question. My question is, without any notice, how you have deducted the amount from his gratuity and pension? It is a question. Not the area reject so that I cannot, I have not say anything in rejoinder.
Board should answer only that question.
My lord.
No other question.
No.
You have put me to difficulty now.
My lords, this is consequence to the adjournment.
Refixation challenge failed, and therefore that money, public money, where from that should be recovered. That you have recovered from them. But his question remains. You notice to it. So if a show cause notice they will give you,
and then I will just come to the court again.
So you have come to court many times now. One time we will be here. Your client is here many times.
My lord.
See, refixation was done.
Refixation was done.
1 second. Is it true? Is it
refixation is allowed or not?
No, that I'll come to that. Now I am asking this question to you so that to understand your case in a better perspective.
More, I want to know why they have deducted the amount from a gratuity
without
and pension without any intimation.
They are saying we lost the case and therefore we have recovered. They are saying you lost the case before the trial.
That is a separate issue.
No, in that
I have challenged the refixation of his pay after his return from his post. Deputation with the order of the tribunal, he has drawn some amount. I have still paid.
It was interim order.
It may be. That does not arise here.
That question arises. Your question also arises.
Yes.
And he has answered that. Our question you are not able to answer. Then case has to be dismissed.
That has gone already.
No, this case also.
This case without any notice how they were deducted from the gratuity.
You hear him, brother Behra. You hear him. And if you are convinced of his hearing, then return that money. If not convinced, you reject his contention. That's all. He wants right. He says, adamant you were given opportunity hearing by the God. You give me that opportunity.
My lords, what I humbly submit, he cannot develop any, because it has been affirmed by both the courts. The due is there.
When you get to the due is there, that he agrees. But can that be recovered from the gratuity? Second question is, that too without notice. His grievance is notice. He is not worried about other things. Why the postman did not come to my house? That is his case. You send notice to him. You hear him. Anyway, this is a case of post-decisional hearing in like Maneka Gandhi. We extend that proposition to this case now. Where did you give a notice saying you have lost all your cases and therefore we want to recover from the gratuity? That you have not done is the case of the petitioner. What you say is he has lost all cases. He himself is saying that.
My lords, kindly see.
Para 6 I read completely.
No, my lords. Annexure CY6, page 15.
Page 15.
Of the counter.
The counter.
detailed order was given. It was not that he was not given opportunity.
No opportunity has given to me.
What is this?
ଗୋଟେ ରିଡ୍ କରିବି ଗୋଟେ ଆପଣ କାଉଣ୍ଟର ଦେବେ ଗୋଟାକର
Kindly be seated for some more. Petitioner has scripted his prayer as follows. Basanto. Basanto can be used in single, in plural also, any other word? No. The same word. Okay. Basanto G. Not G. Your G. Yes. Cabinet counsel for the petitioner vehemently argues that post-retirement, no amount could be recovered from his gratuity stroke pension, much less sans notice. First, in support of this, the cites decision of the apex court in State of Punjab versus K.R. Erry, Erry, E-R-R-Y. A.R. 1973, SC 834. And State of Punjab versus Iqbal Singh, AR 76 SC 667. First. Next, madam. Learned AGA, Mr. Behura, drawing attention of the court to the counter filed by the OPs, more particularly the order dated, that order dated 16/1/2024 at Annexure 8 submits that petitioner was given additional amount which he was not entitled to because of he is lacking a particular educational qualification, semicolon. The pay of the petitioner was refixed, eventually resulting into recovery of certain amount from him, which was paid in excess. He had laid a challenge to the same before the Odisha Administrative Tribunal, Odisha State Administrative Tribunal, OSAT, OAT, which denied relief to him. He also took the matter in challenge before the coordinate bench. Division bench. Division bench. And it met the same fate. First up. Mr. Behura submits that the public money cannot be retained by a public servant, especially when he is challenged to recovery, challenge to refixation pay has been negative. And as a corollary of that, recovery has been done. So contending, he seeks dismissal of the petition. Next. Having heard learned counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission of learned counsel, Mr. Behera, that this petition is nothing but a shadow boxing, essential disputes having already been settled by the tribunal and by affirmation by the division bench of tribunal's order. First, next paragraph. The above being said, there is a process for recovery. There is a normative process for recovery from the gratuity or pension. Once the a public servant retires, first, counsel for the petitioner repeatedly raised a question as to why no opportunity of hearing was given to his client before effecting the recovery. First, principles of natural justice are sacrosanct. And the apex court in Maneka Gandhi versus Union of India has held that courts in its discretion, courts in their discretion may afford post-decisional hearing in appropriate cases. There are 78 Supreme Court, 80 Supreme Court. 78. Yeah, 78 Supreme Court. See, so and so. Next paragraph. In the above circumstances, this petition is disposed of, directing OP number. Which OP should give notice? DEO. OP number 6. To
5, my lord. 5.
DEO. Number 5. To conduct a post-decisional hearing in the matter after giving an opportunity of representation to the petitioner. First, this to be accomplished within a period of 8 weeks. First, all contentions are kept open. All right, they will issue notice to you. You reply to that. If they are satisfied, they will refund that money to you. If not satisfied, they will retain that money with them. But whether the amount recovered should be handed back to the petitioner would depend upon the post-decisional hearing. Depends upon the inquiry. Okay. All contentions are kept open. Yes. One more matter. Item 56.
My lords, 56. My lords, I pray a little time to file counter.
Very regulation. Containing since more than ever 30 or 28 years.
Everyone wants to file objection. Short accommodation. Yes, you will give 2 weeks time to you.
Well,
you serve a copy and then file it.
Well,
Behera granted a period of 2 weeks for filing the counter after serving advance copy on the counsel for the petitioner. First, call after 2 weeks. Call after 3 weeks.
That may be fixed.
Yes. Date.
That may be.
We have some difficulty, sir. If 3 weeks, if it does not come, you move a memo. I remember.
Yes.
Okay.
ষাঠিটা দেখিয়েছে ফাইলটা প্রথম পাঠানো হচ্ছে আইটেম 60
Yes, but also mention some cover matter and taken up for tomorrow. For his asking for cover matter. Cover matter. I will wish to. Take out password. Okay, come now. Item 25.
My lord, the petitioner's salary was stepped up by direction of the Honorable Tribunal under Annexure.
Make use of mic.
Here, my lord, the petitioner's salary has been stepped up under Annexure 3 after the direction of this Honorable Tribunal, my lord. But subsequently, after her retirement, an amount of 2,04,396 has been deducted from our retirement or dues or DCRG, my lord. Fact remains that he has received what he has received is at par with that of the juniors, my lord. In this regard, he has filed one representation under Annexure 5 that is pending before the opposite party number 5.
Where you sought for refund of that money?
Yes, ma'am.
They had illegally recovered that money from you.
Yes,
that's your case.
Yes, ma'am.
You consider that representation, Mr. Lenka? But petitioner, a retired employee, has made a representation to the OPs on 18/6/2025, requesting them to refund a sum of rupees 2,04,396 recovered from his terminal benefits, allegedly without justification. First, learned counsel for the petitioner submits that if a direction is issued to consider the subject representation in accordance with law and in a time-bound way, his client will be satisfied. First off, learned DGA Mr. Lenka, on request accepting notice for the OPs, fairly agrees with the proposal of the counsel for the petitioner, subject to the condition that a reasonable period should be prescribed for consideration and that all contingents of the party should be kept open. First, this is absolutely fair. Next paragraph. In the above circumstances, petition is disposed of 8 weeks, contentions open to solicit. It has made to all the parties.
Copy to maybe directed to.
Okay.
No,
of course. Okay.
Item 44. May I plead lordship? My lord, a commercial suit was pending before the Land and Commercial Court, Bhubaneswar, wherein the written statement of the present petitioner has not been accepted.
Yes.
Though the other defendants, the written statement filed by other defendants through the same written statement has been accepted, but the written statement filed by the present petitioner with the defendant number 1 in the court below has not been accepted. So,
when notice was served on you?
My lord?
When notice was served? When summons was served?
After the statutory period, I have filed the...
that's what. Therefore, you are not entitled to have it. Covered by settlement.
Well, the specific claim of the present petitioner is that the opposite party number 2, who is the one of the director, was the son of opposite party number 4 and opposite party number, both these are the directors of the company. And the opposite party number 4 was in ICU. So that ground I have taken in the acceptance petition, my lord. So
number 4 was in ICU.
OP number 4 was in ICU.
But your client was very much, he was in the gym.
The present petitioner has been represented by OP number 2 and 4.
2 was there.
2 is the son of OP number 4, my lord.
Makes no sense.
My lord,
it was OP number 4 who was in the ICU.
OP number 4 was in ICU, and OP number 2 is the son of OP number 4.
Correct.
So, in order to for the treatment of his father, he was not able to sign the written statement.
But you were capable of doing it.
My lord, the petitioner has been represented by OP number 2.
That makes no sense. Your representative is none other than agent. my lord. What agent can do? The principal can. What principal can do? My agent may not do. That's the law. Not very judgment.
That may be liberally considered, my lord.
How?
Since
But together we have to go to Delhi.
no.
You may do that. Petitioner who happens to be the defendant in the commercial suit in what is that number?
My lord, CS number 677 of 2021.
677 of 2021.
Within the bracket money.
He is knocking at the doors of report for assailing the order made by the learned senior civil judge, commercial court, GBS, Bhuneshwar, Bhuneshwar, on dated
10/10/23.
On 10/10/2026.
23, my lord.
23. Whereby the written statement, what do you call it? Written statement?
Yes, ma'am.
The written statement proposing to resist the suit has not been accepted on the ground of delay. First of all. Next paragraph. Learned counsel for the petitioner vehemently argues that he had been represented by OP number 2, who is none other than the son of OP number 4, who was in ICU on hospitalization, and therefore there is absolutely no justification whatsoever for the impugned order to exist on record. First of all, having heard learned counsel for the petitioners, one petitioner, and having perused the petition papers, this court declines indulgence in the matter for the following reasons. Next paragraph. It is open to the petitioner to assail the decree if and when he suffers in the subject suit by taking the impugned order as one of the grounds as provided under Order 43, Rule 1, capital A of amended CPC 1976. First off. Next paragraph. We'll say only this much so that your right can be retained.
May be permitted to adduce the evidence.
Yeah, without this one also. Is there, if you do not file a WS?
Yes, my lord.
Is there any decision which says filing of WS is a precondition for cross-examination?
No, cross-examination I can do, but defendant number 1, I can adduce my evidence. That liberty may be given.
On that, conflicting judgments are there.
Yes, my lord. That liberty I only place.
You seek liberty at the hands of the court below. I'll permit you to move application.
Yes, ma'am.
The contention of the petitioner that without a WS, his client may face difficulty in leading evidence either by way of examination chief or of the cross-examination of the witnesses of the plaintiff side. First off. This aspect of the matter may be examined by the trial court itself if an appropriate application is moved by the petitioner. Because conflicting judgments are, yes, I have seen that. Next one. In the above circumstances and with the above observations, petition is disposed. Petition register to send a copy of this order to the OP space. Be post immediately. Okay. Must be legal for 57. Huh? Must be legal for after 57. 57. Item 57.
Item 57, the Lordship on last occasion directed me to sub required number of writ petitions, but I could not file inadvertently. Lordship may grant me some time, and in course of day I undertake to of the copies.
You do it in 2 days.
Great.
But my lord, apart from that, the main prayer which has been made by my learned friend, so far the payment of arrear is concerned, let them take instruction. My instruction is in the meantime this has been paid.
That I have received from 24/7/2010 to 28/10/2022. I have not received.
You have not received?
No, I have not
The
received.
total amount as per my instruction, it has been paid. So let him take instruction.
You take instruction.
By that,
No, what order to be made? Call after 2 weeks. The request of. Item 58.
Great.
Now listen.
Yes, sir. Already it's regarding the compliance of the order of this Hon'Ble Court. My lord, 2 sentences I would say your lordship had observed that the order of this Hon'Ble Court is as clear as Gangetic waters. And the order was to be complied within 10 days.
The principal post, etc.
My lord. And the to compound my use,
And so far the inter-transferred rule is concerned 1979. But what you say
That is common cash.
common cash
1979.
that can be transferred from one college to other college.
Inter-transferability.
Inter-transferability rules, 1979.
And director is the computer.
Director is the computer. That is the.
So there is no wrong at all committed by us.
But wrongs in the sense you made the appointment and that is the epicenter of all wrongs.
And what my learned said, it is also, so far the cadre is concerned, that cadre was not analyzed for a long time. In fact, that table of the Penascus considered by the council there, the court said that there was a judgment early in the 1985 that you must give effect to Rule 83, that is a statutory rule. So that is what the honorable coordinate bench said, that you must comply with the Rule 83 and must make a common cadre. You can't fill up the post by giving appointment as principal in charge. There is no post of principal in charge. So regular principal has to be done in accordance with provision Rule 83. And they made a common cadre which was found to be defective and stay order has been passed.
Once it is made common cadre,
right, sir.
Then the unit of consideration is not the institution.
No.
Question
As a whole.
That is, as far as principal in charge is concerned, that is a stopgap arrangement and there is an executive circular, executive instruction.
Which confines it to institution itself.
Yes.
But for regular
Rule 83 is applicable.
83
74 rules. That's what I was missing.
There are 23 rules. Appointment of the principal now. Appointment of the principal in 2023, they have brought in a rule also. So now the
separate are made now.
Now they have a rule.
New rule has come.
Where is that rule?
That rule
I not come out of the government.
No. I'll get that from here. I can.
That is a resolution. That is
Resolution.
I'll get that, my lord. No.
All by resolution. Like Sugriwagni.
They pass resolutions which nullify the rules. That is
therefore I must.
No. We are implementing.
So my taking all these issues into consideration. All these issues exactly.
No, I want to say, where is that resolution?
I am not carrying about it.
You should give that.
I can get that, my lord.
How government can make appointment, I do not understand, to the aided institution. Giving aid cannot result into robbing of the autonomy of the institution. The very object is the autonomy should be retained with financial aid of the government.
They have totally destroyed the autonomy of the institution.
No.
By
we have not.
Dissolving.
It is only destroyed the institution.
My lord, your lordship had taken a view when I came before your lordship, challenging their order, whereby they dissolved all the governing bodies of the state. So thereby, and put the sub-collector in charge of the colleges. Therefore, the autonomy of the institution is lost there. There and then itself. Because
policy, I don't want to see. That is called, it is in 8/11/2024, they have been subject is guideline for posting of principal in non-government aided colleges under the higher education department. This is the
What is meant by non-government aided?
This
type of aided.
Let's say non-government aided
Question of if it is a government institution. Where is the question of aid at all?
That what? Non-government
aided.
This is the policy.
Get that copy.
My lord, I could.
I will post it next week. We will have this matter. In the meanwhile, I will have some. I will also make some reading.
Madam, without salary, kindly early next week. 3 months I am not getting any salary.
Salary.
My lord.
For reader's salary also.
Salary. No, they have not. Stop 3 months.
Reader salary.
By an order, your lordship. By an order, they have stopped my salary.
My lord, lordship is calling this matter next week.
Question is not that. Why is salary stopped?
Salary should not be stopped.
That's what I it is stopped.
You should tell it to your client, not to him.
Salary is stopped for 3 months. And your lordship.
You release the salary.
Yes,
and they are saying that the
counsel for the petitioner complains that regardless of his claim to the post of principal, admittedly, the line continues as the reader, and therefore there is absolutely no justification for withholding the salary admissible to the post in question. First what is your contention?
My contention, I will get instruction why the salary is stopped.
Mr. G seeks time to take instructions and come back. First time. How many years of service you have got?
I'm to retire this November.
November 2025. No.
Call this matter on Thursday. At least on Tuesday we'll call this for salary. You can't withhold the salary of a person who has served so many years.
They should not go without salary.
That's what. Yes. So many cases where pension is not paid, salary is not paid, selection is done, appointment orders are
Your
not
Lordship
issued.
observed that there is some conspiracy. This is the conspiracy. They have.
Deny that.
You're not saying
No, sir, you instruct your Mr. G.
My lord,
Unless there is some reason I can understand. Unless there is some reason, you cannot withhold the salary of a. But it's his property. I have held in myself and Sahu, we have held. It is not only money, it is property because his sweat and blood enters the soil.
Item 59.
Here, my lord, we have to file the counter.
That's 2 weeks for filing counter. Yes.
Item 16.
This is a case which is squarely covered by judgment of the coordinate bench and given a copy to my lord. Last time, Lord, hard this matter also said that you take.
They wanted to verify and come back.
That is squarely covered. Lord, remember that case?
Give copy that.
Page I have already given. Twice I have given. My lord told also to see.
Connected record is not there. I pray only next week.
First day we will have that. My lord. That day again, no. If it is covered, it is covered. Why?
Just the record is not there.
I am appearing in the connected case. My lord is appearing in the first case. The principle is same, I think, both the cases. The point is this, Lord, just for my reference, because he was not the last time. A college which has got concurrence prior to 1489, and this is a college which got concurrence way back in 76. And the judgment was delivered by this Hon'Ble Court where the cut-off date that 1489, the state government came up with a resolution that prior to 1489, those colleges have got the direct payment, they will get the UGC scale of pay. That was the subject matter of challenge. And here this Hon'Ble Court declared ultra-virus of that 148, cut-off date 1489. It was challenged before Supreme Court in Austin Das case. In Austin Das case, it was held, no, it is intra-virus. But it was held that is in respect of college, not in respect of a post. And that has been clarified by the coordinate bench that a college, it has got the concurrence prior to 1489. That is not it. But let me not.
That's what.
Have you got the copy of the judgment?
You at least to give one more copy. So one more copy. Cannot spend the time in that.
Have you got that copy or I'll give it another? Yes, copy. All right, so keep it first.
Item 61.
Unless the assignment changes.
May I please come up?
Yes.
This is the read 2 decades old and 4 decades old issue involved, my lord. Last occasion, my lord, near council of the BDS took time, my lord. We permitted to place the case because interim order is not there. Even if it has been restored by CMEPL a year before, the interim order was not restored. So, my lord, if they are praying now, again they are praying for time. So, I humbly pray that at least the interim order be restored.
What interim order?
No coercive action, my lord. Because It is already, I have filed a dead chat, my lord, to assist your lordships. If your lordships will permit.
We will decide the matter itself.
Yes,
So,
my
You
lord.
can decide the matter.
Obliged, my lord.
One request, my lord. Actually, the matter was disposed of, and for that reason, CMAPL was filed, and it was restored again. So the brief has been. We are in the Puja Chutti also. We have tried to trace out the brief, my lord. We could not trace out the brief. So I will take a Xerox copy of the brief from
Last occasion, they had said so, then I must have provided them. Because through WhatsApp, I have that with provided the orders.
you give him.
Yes, I will Xerox it and give. Yes, my lord.
I will take Monday.
Monday. No problem. I will take a Xerox copy from my lord senior man.
Give him full copy.
Yes, man.
Yeah. Including your notes.
No, notes are already supplied. He is holding the notes
Already supplied, man.
Notes already. He is holding them. Obliged, man.
Obliged.
Yes. 62?
My lord, in 62, I am appearing in VC, my lord.
Yes.
But this brief is just transferred today to me, my lord. I will file Vakaltanama. I request my lord pray for next week, my lord.
1999 matter.
99 matters only pray for next week, my lord.
Monday we will have this.
Monday we will dispose it of, my lord.
Okay.
My lord, much obliged, my lord. Monday.
Get the request. That also. 63?
May it please your lordship.
Yes.
My lord, Pirisa was an employee duly appointed. Then, due to some mistake of facts, criminal cases, he was implicated in criminal cases. Then he was arrested and then disengaged from service. Then he faced the criminal trial and at last he was acquitted.
Is it honorable acquittal?
Yes, my lord.
In the light of Ramlal?
Yes.
When a disciplinary inquiry was held against you?
No, my lord. I was disengaged. Disciplinary proceeding is not. No,
You're part-time PhD. Part-time, involved in a criminal case.
The criminal case involving which offense?
The POSCO Act was.
My lord, the order of acquittal is Annexure 6. My lord, kindly see
No,
the
that
order.
acquittal all right, but a person accused of POXO offenses.
Yes.
Mistake of
be
fact.
reinstated. What should happen to the children? How parents will.
My lord, kindly see, he was falsely implicated. Mistake of facts.
Where is that
My lord,
observation?
kindly see, he has faced the criminal trial. The order of that acquittal.
No,
the
acquittal
annex here is as
acquittal is on what ground? False implication.
false implication.
Where is that? Which paragraph says falsity of implication?
Lord, kindly grant me 5 minutes. I will.
5 minutes?
Yes, my lord.
You sure that?
My lord, kindly one Passover. I will see.
One Passover
One Passover.
or one adjournment?
My lord.
One adjournment.
Next week.
Adjournment.
Yes, adjournment next week. Next week.
Week of next. Yeah, get the request comes. Item 64.
64, can we do one item Passover?
Passover.
One item. So there is coming. I have five.
Passover.
One item finished.
Can you give Passover?
But my lord, I favor this may be taken up.
Taken up today, my lord. I will be sitting here only, even if Cobra comes at my leg. No, the question is, you should be ready.
A small matter.
I have no objection for Passover.
Pass. 25 matter it is. Both the matters are 25 matters.
No, what happened? There is an interim order. All the appointments have been stayed. We have been selected we have passed the exam, but we are unable to get the appointment. I filed it. My friend is for the agency.
Item 66. Yes, sir.
The allotment of the defense. Is the defense 18 years old allotment of plot, madam? Bhubaneswar.
Allotment of plot.
Defense person allotment.
Oh, that one.
Yes, that plot is still available.
But he says, but I have no instruction about availability of that plot. Lordship, I had also communicated their lordships, communicated letters to them, but no instruction I had received as yet.
Who should give instruction?
GA department.
GA department.
GA department.
Will direct the secretary to be present before the court.
Lordship, if your lordship will call this matter tomorrow, I'll try to get the
call tomorrow at the request of learned AGA, Mr. Chi. Yes.
Can it be taken up 2 o'clock? 2 p.m. so that?
No problem. If anybody is there, Passover, anybody can send.
No, Passover, I don't think it will not fix it tight so that they can come with a concrete instruction.
I will get that. I'm trying to get that. I'm trying to help you.
Yes, 2 p.m. Okay. 67.
Item 67, Your Lordship, I pray for 2 weeks' time to file an reply to the additional counter affidavit filed by the opposite party.
When it was filed?
Your Lordship, I received it on 29, Your Lordship.
23 matter.
Yes, Your Lordship. Your Lordship, short.
2 weeks at the request of. Yes. Item 68.
68. Though I am challenging here the order of transfer because I have filed the case. Now the authorities have placed me under suspension and proceeded against me in the proceeding. I have challenged it in a separate petition. I could not get the number. May I pray, my lord? Can it be next week so that I will collect the number and can we take up?
2 weeks?
Next week. I have filed the case already, but number I have not. Next week,
call this matter along with WP number.
So in that number, I have not
along with
received the number.
matter, I will say. You have to registry and tell them.
No, because now there is a delay in getting the numbers because there is some paraphernalia has to be processed. I could not. I have tried before lunch also. I could not collect. That's the difficulty. I will give. My lord, just simply adjourn this case to next week. In the meantime, I will collect it.
At the request of.
64, my learned friend has come.
Yeah. 64.
Yes, then is my learned friend has come.
You were playing participated in the inquiry, in the recruitment process.
Yes.
In fact, my lord. Why can't you give 2 days to boss? What will happen? He's not well.
Well, it only once or something.
What will happen? Within 2 days, nothing will happen.
Not
only one suggestion matters next week. Yes. It will get well. Yes,
May I suggest one thing, my lord? Only there is only one person filed the case, entire 2,000 post has been stopped.
I will assist you.
My lord will keep one post for this person, then everything will continue.
Assist your lordship.
No, I am just asking. If one post is kept vacant for you, all other how you will be affected by that?
My lord, we have challenged the entire procedure.
That's how.
My lord, I'll assist you.
No, that's not it. That what Dasap says and what your brother says appears.
My lord,
the order is modified to the effect that what the post shall be kept vacant.
My lord, your lordship,
to accommodate the petitioner in the event he succeeds in the matter. Nothing will happen.
My lord, your lord,
other posts the recruitment process to go on, subject to result of this case. My lord, subject to result of.
My lord, may kindly hear me for a moment. Kindly hear.
Next.
My lord, may kindly.
Mr. Bose, I tell you, sir, there should be a limit. See, you should protect your interest of your client. We are saying we are keeping one post vacant. First, number 2, we are making other processes subject to the outcome of the
No, it is not like that, man. Your lordship,
how you are agreed? You are keeping one post vacant.
No, it's not like that, man. Your lordship has every right to pass any order. I'll accept it gracefully. But here the case is little different. Your lordship, may kindly turn to page 15 for a moment.
No, I do not understand how in a wholesale way
Recruitment process can
No,
halt it.
here your lordship had heard it me twice.
Correct.
Your lordship heard me twice. Directed the state to file the counter because the anomaly has been created by the state.
That's true, but why you want to hold the entire process?
No, my lord. Your lordship may kindly turn to page 15 for a moment. My lord, here an advertisement was issued on 22/10/2024. My lord may kindly see TGT Arts. The total seats is 1984. Page 17, your lordship will get it.
And you participated in the recruitment process.
Yes, after seeing the judgment of the Honorable Apex Court,
there are many 64. But how can you hold the entire process?
My lord may kindly see page 17.
Yes,
17, your lordship's in. Total is 1984 seats, TGT Arts.
Yeah.
Then another notification was issued under Annexure 2, page 32 on 2/1/2025. In that, my lord may kindly see, from TGT Arts, the School and Mass Education Department, Odisha, wide notification number such and such, have decided to earmark 25% of 1984 vacancies of TGT Arts, 496 vacancies to the post of TGT Odia.
Because I suppose if I want to, even if I want to allow the petition,
yes,
the interim order should be consistent with that.
Absolutely.
Number one.
Yes.
We are saying one post should be kept vacant to accommodate you, number one. Number two, whatever they are doing is subject to outcome of the petition. Can you withhold that?
If your lordship ultimately holds that the state could not have done so,
everything will.
But that is the reason with consciously this Honorable Court passed an interim order.
Therefore, consciously I am making
and my lord, and after hearing me substantially, my lord, if your lordship may see the entire order sheet, your lordship continued the interim order. This is the third time I am appearing before your lordship in this case. And your lordship was kind enough to direct the state to file a counter.
That's all. Well, assume that you have got a wonderful case now. And you will succeed also.
Mala, let it be on Monday. I will assist your lordship. Let it be on Monday. Mala, today is Thursday.
No, but many works, many of the.
Mala, let it be on Monday. Mala, if I
matters we have pushed.
Mala, if I don't convince your lordship on Monday, your lordship may pass that order.
No, heard both the sides. Come on, this court-wide interim order dated so had interdicted the entire recruitment process.
Therefore, TGT, Mala, the intervention.
What is your post?
Odia.
That I will keep on post. I will keep on post vacant. And your new posts I will keep vacant.
No, your lordship may then say that any further procedure will abide by the result of the writ application.
I will say that. Learned councillor.
My lord, the connected matters posts are there. Your lordship may keep that also because that will.
You tell me how many posts should be kept open. I will keep them open. For rest of the people,
10 persons.
10 persons. How many persons? You are only one person.
If one is one person, another 10 persons. 11 posts. 11 posts. Let it
say them, but keep this post by the modern going so had integrated the recruitment process in a wholesale way. Learned advocate who proposed appearing for the petitioners submit that there are as many as 11 candidates and that there is absolutely no reason for varying the interim order, twice the same having been continued intact. Next one. Learned counsel appearing for you appear for
Staff Selection Commission.
Learned panel counsel appearing for the Staff Selection Commission. And learned
interveners.
Advocate appearing for the pleading applicants. Vehemently submit that ordinarily interdicting entire recruitment process is not desirable and that justice to the petitioners can be
done by keeping as many posts vacant and further vacant first off. They also submit that the recruitment process as scheduled should go on with the mutatis adaptability subject to outcome of the petition. First off, this stand appears to be fair and reasonable because that would make the two ends meet with no prejudice to petitioners. Assuming that petitioners have got an excellent case on merits. First, next step, in the above circumstances, interim order is modified to the effect that the scheduled recruitment process shall go on.
Final result may not be given.
No.
Hear me.
Outcome of the petition.
Yes, sir.
Okay, first one. However, 11 posts shall be kept vacant so that if the petitioner succeed in the petition, they can be accommodated there. Over. Why? What?
One more. Your Lordship may direct the state to file a counter because.
Can I direct? Can the court direct the defendant to file the WS? We can decide it. We can take advantage of absence of
Your Lordship may fix
WS.
Your Lordship may fix a date for a hearing. Early date, because this is examination matter. That's why I'm praying the early date. Any date suiting to your Lordship's convenience.
The second week of November.
Yes, ma'am.
That 11 post, ma'am, sorry. 11 post in TGT ODIA category. TGT ODIA. Yes.
TGT ODIA.
ODIA.
Second week of November. Great. But not a date. I'm just praying for a date.
Well, let us see, because we do not know. Changes may also occur. I do not know. Yes.
Any date suiting to your Lordship's.
Let us see. I can't fix date for my brother judges. I'm not sure whether I will be. This will continue. But don't go by speculation also that the roster may be changed. This we do not know. That's the okay. Next.
Item 69. Second week of November.
Second week of November.
If it doesn't come, I may be given the liberty to mention.
Yes.
Item 69, Milots, I'm appearing for the petitioner, Milots. Milots, this is a case where 85 number of students have approached this honorable court, Milots. 85 number of students from Rinkuraj College, Milots, who could not appear in the +2 final examination, Milots.
+2 final examination.
Final examination in the month of February.
Last February.
This year, February, Milots. Milots, because due to administrative delays and due to administrative disputes between the university or the principal of the college, whatever it may be, Milots, these students were not supplied admit cards, Milots. Milots may be allowed to place a date line, Milots, just to clarify that how the rejection order that was passed by the university, Milots, in the month of May, they outrightly rejected the representation of the petitioners who requested them for a chance of re-examination, Milots, because they will lose an whole academic year because of some administrative fallacies on the part of the administrative officials. Because
who are they?
Milots,
who are those administrative officials according to you are at fault?
Milots, I am not pointing to the said person because we are unaware of whatever the procedure.
Already in the matter. All right, start.
Milots, on
what is your prayer?
Milots, my prayer
for re-examination.
Fresh examination.
Fresh examination for those who have been illegally deprived from giving a +2 science examination, which is a
Why you were deprived of that opportunity?
Milots, I'm coming to that, Milots. Millards, may I place the timeline, Millards, for the better adjudication, Millards?
Very well, whichever way you want to, but ultimately it boils down to
one thing.
Deprived of that much.
Millards,
it will not happen without any reason.
Millards,
with some reason it happens.
Millards, on 9.
1 second. Listen first, so that you can be more effective in convincing me. Because my doubt should be clarified, na? Yeah. Why you were not permitted to take the examination in a wholesale way? All 85.
Millards, the 85 students belong from the same college.
Same college. So the examination center is also same?
No.
Different.
The examination center previously used to be the same college in which the students used to study. Now, according to the counter that they have supplied, according to the reports, which are not available to us, Millards, we are mere students, they have found some irregularities, alleged irregularities in the said college. That is why they shifted the examination center.
Correct.
Millards, to understand the difficulty of why these students could not appear in the examination, it should be kept in the background that these students belong from very rural areas, that is backward districts, that is Mayurvanj, Millards, where accessibility, even telecom accessibility is not.
1 second. To which place examination center was changed?
Millards, to Karanjia Autonomous College. Karanjia.
How many kilometers from your college?
17 kilometers.
17. Whether bus facility, commutation facility is there?
Everything is there.
Everything is there. What you say?
Millards, as per my instructions, there are limited number of buses which ply from the
Karanjia town, my lord.
No.
College is
Karanjia.
Karanjia.
From there, new centers are
Karanjia Autonomous College.
No. College is at Badgaon, Millards. Badgaon.
Now it is only 17 kilometers.
17 kilometers.
Okay. Where have you taken up the contention that the commutation facility is not available?
Let's
show that. Why all 85% are from this college only?
This college only.
And they shifted you to, because there may be copying, etc., whatever, we don't know.
Yes.
In their
infrastructure,
they felt that you should take examination in X center. Why did you not go there?
Millards, that is the secondary question of consideration.
No, that's the primary question for me.
Because, Millards, on the date in which the principal issued a notice for us to collect the admit cards, they were not supplied within the timeline which was given to us.
Admit card was supplied to you when?
Admit card was never supplied to us.
Who should they supply?
The students.
No, who should supply? College.
Principal has invited to students to receive admit card. Prior to
where is that letter?
That is letter, my lord, annexed G/4. We have our counter, my lord, G/4. G/4, my lord. Our counter we have stated. They have principal has requested the students.
Read,
my lord, all the page 42.
All the students who have
filled the examination form for the annual Upashastri examination 2025 are hereby informed that the admit cards will be disturbed as per the following distributed the following schedules date by so my lord.
Then put to notice board.
That is their notice board.
To the college.
Their college, my lord. After received admit card, they have issued circular to all the student invite.
Who are you?
I am the university, my lord.
University,
my lord.
The university sent admit cards to the college.
University sent to the admit card to the concerned college.
When?
On 19th, my lord. They have received.
Right now.
I am appealing for the principal.
He sent the admit cards for the ensuing examination
21,
the
21,
college on
21 to 25.
21 to 2025.
My lord.
Milots, that is the center, college in which center is given, not to our college. They sent the admit cards to the center.
May please, Your Lordship, my lord. I'm appealing for the principal.
All right, you answer his question. Whether this was sent to which new center?
New center, my lord.
That is to the new center. But to the college you did not send.
No, my lord.
No.
Then they have also sent.
We received it on 22nd.
Soon after receiving.
The principal of the college received the admit cards on 22nd at 5 p.m.
22nd?
22 to 2025. The exam was on 24th, which was Monday. The principal received the admit cards on 22nd, which was a Saturday.
Correct.
At 5 p.m.
All right. Why you did not distribute it to the students?
We should have noticed, but Sunday being a holiday, and on Saturday the college timings were already over. So
examination time, should we not send the intimation?
We have intimated
to the students.
We have intimated.
Okay. Did they intimate you to the?
Due to inconvenience, that
Milots, the intimation that we
are asking you the question.
Yes.
It admits binary answer. Yes or no? You can explain.
Milots, it cannot be a binary. It cannot be a binary answer because I'm representing 85 students, Milot.
You correct, all right. Whether it was supplied to you or not is the question.
Admit card has never been supplied to us.
Oh, supplied means what is the procedure? You should go to the college and collect it.
We went to the college on Saturday, Milots.
Correct.
Saturday there were no admit cards.
But evening they received and they sent intimation to you.
Milots, they received after 5 p.m.
Why? What happened? You are not being invited for marriage ceremony. You should be serious. It's an examination.
Milots, I bow down to that fact, Milots. Milots, the timing also that has been prescribed in the said notice is up until 5 p.m.
That's all right. The examination was on Monday. Saturday evening 5 p.m. they received it.
Milots.
It's a question of examination. It is like wartime situation.
Milots, as per the instructions that the students have given me,
my lord, another one staff is deputed at the examination center till 2nd 25, 8:30 a.m. But till yet, no student will be touched him, and neither they have received nor they have appeared examination. Because of their laches, now they have only sole claim. At any cost, we will examine our center, my lord, not the.
That is never not my prayer in this writ petition, Milots.
Yes.
My learned serious.
Why did you not go and collect the cards?
Milots, first of all, the admit cards were received after the collective students went home from the center because till 5 p.m. the institution did not have the clarity where the admit card was, Milots.
All right, the institution did not have. You knew. On Monday, examinations were going to be written.
Milots.
Why did you not wait?
Milots, the institute
is not classroom. You were waiting for the admit cards to come. You should have waited there till 12 midnight.
Milots,
your students.
Milots, I bow down to that fact. That Milots, that fact also needs to be taken into consideration. That these students who are students who are facing +2 examination, and they must be in a mentality, Milots.
Mentality.
They must be in a mentality to attend the examination.
Mental state.
Must be in a mental state. Milots, when they're on the day preceding, just one day before the examination, they get to know that due to all these things, their center have been changed.
17 kilometers.
Their center have been changed.
Which is the nearest wine center and which is the nearest talkies, cinema theater to the college?
My lord.
No, I'm asking a question because I want to write the judgment. Which is the nearest wine center from the college? And which is the nearest cinema theater?
Nearest
culture is not there, perhaps anyway. Therefore, I am not asking that. My question is, why the students went away without receiving the hall ticket? Which serious student would go?
Millards, because the college was not able to inform us. They had.
They say they have informed.
Millards may kindly look into the series of letters that they have issued to the Vice Chancellor as well as the Principal of Karanji Autonomous College, which is designated as the examination center. If the authorities would have had the idea, they would have not written in those letters that we have not received this.
Simple. One day was intervening.
Yes, on Sunday.
What did you do on Sunday?
Millards, my instruction is that those students were not duly informed because Millards,
but everybody knew 22nd is the date of examination.
Yes, Millards, but the possibility of getting the admit was not informed to them. The possibility of getting the admit, because these students are tribal student Millards who live inside the jungle where network areas are not available. Millards.
Let them live there only. If they want to come out of jungle area, they have to do some exercise. The first exercise is sitting in dharna over the college or in the premises of the university, saying that, Mr. Vice Chancellor, you cannot deprive us of the examination. The examination is on 24th. Kindly give us the card. How students would behave if admit card is not given? We will not eat our dinner at all. It's not that simple.
Millards, I bow down to your lordship's observation.
You are saying, but you need not bow down at all. I also bow down to you. Then I'll write the judgment.
Millards, the thing is, Millards, whatever has happened, Millards, they have in the rejection order.
When the next examination?
Next examination going on some February 2026.
Yes,
next permission form fill up will start November last week.
Except there,
we have no hesitation, my lord. We have full sympathy with the students. And if the students will appear ex-regular students, they can appear ex-regular. Ex-regular, they can appear ex-regular students, my lord. Because university has no fault, my lord. University has issue, my lord.
But now, if once they are shown as ex-regular,
my lord,
where will be the employment opportunity? That itself will diminish the employment opportunity. It is as good as saying, don't take this student.
As a regular student, but ex-regular student, because of they have deprived one chance, my lord.
But now there is some problem. Don't treat it as excellent. That will be too harsh to them. See, number one, they come from rural background. Completely rural background. At least arguable. Don't treat them ex-regular. In the special circumstance of the case.
Your lordship,
why you sent in the evening? Why did you?
No, my lord. On 21 second 25. Admit card issued by the college center, my lord. The center who have fixed by the university. On 21, same day, soon after receipt at 3 p.m. received the admit card. So immediately they have called for principal, and they did not receive. On the same day, they have also SMS message already given to the principal, and one staff also on the second day. Despite one day, for 24 hours after, one staff is deputed to collect from the admit card from the concert center, my lord. On 22nd, they have received admit card and distributed, and accordingly, they have informed the student to collect admit card. But the university has no latches. University has, prior to functioning of examination, universities are duly informed, and they have also informed to the college. On the principal of the college, my lord.
Anyway, now suppose if you are permitted to take examination on regular basis, will you be happy?
On regular basis, yes.
Take it on regular. Don't mark
your lordship may pass.
I'll pass
direction. Their form fill up will be start from November last week, my lord.
You have to fill up.
They will cooperate.
Petition is disposed of with the following directions. Number one, the prayer for holding the examination separately for the petitioners is rejected. First one. Second one, the university shall permit the petitioner to take the ensuing examination in February 2026. Subject to petitioners duly filling the forms, examination forms afresh and making payment of the prescribed fees therefore. Next paragraph. It is the lookout of the university as to where the examination center should be located. And the students, petitioner or the college shall not have the say in the matter. All right.
Must be reasonable.
Huh?
Must be reasonable distance.
No, they will not send you to some blue lagoon nearby because they have given some reason, because the second time it is argued before me now.
Yes.
Therefore, I did not hear much. I remember whatever you have argued other day.
I humbly pray one.
Yes.
A short direction may kindly be issued to the university to supply the admit cards way before the conduct of the examination.
The university shall supply the admit cards to the college in question well in advance. Say 3 days. Minimum 3 days. Minimum 3 days advance.
Concern examinations. The student of
To the college you are sending that. And college the college shall distribute the same to the students on war footing. Okay. Now, you said that it is made clear that the students shall be needed to be taking the examination not as ex-regular, but regular. That justice is done to everybody. Don't fun. Sometimes students do these things. As a student, did you not do anything?
No.
At least I did. Yes.
Item 70.
There is one matter which under sir has come from Delhi, perhaps. I remember you got this date and you took a chance also. If you are ready, I will take up your matter. You start.
I am for the respondent, that's the only problem. You are sitting now, you went to it.
You are for the petitioners.
No, my lord, I'm assisting. Facts are very, very simple, my lord.
But in the absence of counsel, the university will not help.
5 minutes, but
Can you at least secure his presence? Can you send your colleagues arguing, your briefing counsel to secure the presence of the petitioner? Just go ahead. Kindly be seated. Yes. I remember because the other day you mentioned that.
Already in item number 70. This is a transfer matter. I am appearing for the opposite party number 6 in the first matter. So far as second matter is concerned, my lord, I have filed that writ petition. My lord, first is my lord. The first I have challenged the petitioner.
I have challenged the order of transfer, my lord, on 2 grounds, my lords.
Order dated?
Your lordship.
Dated?
Order dated, my lord, 13/6/2025, my lord.
So 4 months are almost 4 months have lapsed now.
My lord, interim order this has been listed for the 3rd time, your lordship.
Interim order is granted?
My lords.
You are holding
order of
status quo. And my lord,
which other matters? We will post it with the entire list. Give me. I'll post it on
this is already,
that matter has come.
On the my lord.
That matter has come.
My lords.
My lord, I have filed an application for vacation of the interim order on the ground.
No, main matter itself will take.
Yes.
Your lordship, may be permitted.
We have to file counter in this cases so that.
My lord, counter is not necessary in view of the fact. Your lordship may kindly see there is no change of place.
No, my lord, I am for the petitioner. I am for the petitioner.
He's bringing out one factor. The place is not changed.
No, place is not. I'm not on that ground, my lord. Your lordship will appreciate that. Although the distance between both the schools is not
Only 300 meters away.
Not 300 meters, around 1 kilometer.
No.
1 kilometer.
My lord, that is not my ground of challenge, my lord. Before coming to the records, my lords, I had challenged the order of transfer on 2 grounds, my lords. The school where I was transferred, there was no vacancy. But after grant of status quo order, thereafter subsequently they have created a vacancy in the new school by transferring 1 person. So the second ground is, my lord, which is my most important ground, my lord, I am a 85% physically handicapped person. And I also have no grievance on that. But my son, who is having 50% disability of intellectual disability, I have annexed the certificate, my lord, and he needs constant, my lord, assistance by me.
Continuously.
Previously, where I was posted, my lord, that was a co-education school, my lord. So my son, being a male person, was prosecuting studies in that school. But now I have been transferred to a girls' high school where my son cannot study, my lord. And taking into consideration her physical disability, which is an intellectual disability, my presence in the school where she studies is highly required. And this is the government guideline of the state of Odisha, my lords. Your lordship may kindly see.
You are posted to which place?
My lord, your lordship may kindly see the transfer order under Annexure 4. Same place.
Your place is also not changed.
My lord, my place is changed. Your lordship may kindly see Annexure 4 at page 18. That is the impugned order of transfer.
You are from which place?
My lord, serial number 17. I am Ranjan Kumar Naik. My lord, I came from Bodo Simulia Girls High School to Bahuband Girl Ashram School.
How many kilometers?
My lord, that is more than 50 kilometers.
Not that.
Yes. My lord, so far as the petitioner is concerned, your lordship may kindly see serial number 18. Pratibha Manjari Parida. My lord, her previous school is, my lord, to that school I have come. That is Bahubanda Ashram School to Bahubanda Girls High School. Place is same. Only 300 meters away. Only distance is 300 meters.
They have given another reason also.
Well, another that her son is studying there. Well,
not studying there. He has some problem.
Yes, he has some problem. He has some problem.
Yes, 16 lordship.
Yes. My submission before your lordship is, even by joining there, she has already been relieved before the status quo order. She has already been relieved on 21/6/2025. Your lordship may kindly see my vacation petition.
Correct. Relieved.
Yes.
We believe you.
But your lordship may kindly see.
Why say I believe you?
Yes. My lord, I was relieved on 21/6/2025 from my former school. I joined on 21/6/2025 in my new place of posting. I have been discharging my duties in that school as a trained graduate teacher. My lord, her only ground in the writ petition is that there was no vacancy of a trained graduate teacher in that school. Well, to the school which she has been transferred. She has been transferred. Your lordship may kindly take up my second writ petition. In the second writ petition, I have.
Now let us see the medical certificate.
Your lordship may kindly come to page 16, my lord. Your lordship may kindly first come to page 15.
It's a multi certificate.
Page 15 is my disability certificate. I am having 85% disability because
that makes no sense because it is within 3 years.
I am also not urging that, my lord. Your lordship may kindly come to page 16, my lord. That is my son's disability certificate. Your lordship, clause A, he is a case of intellectual disability. The diagnosis in his case is mild ID Down syndrome. He has 50% in figure, 50% temporary disability in relation to his brain, as per the guidelines, such and such, my lords. And your lordship.
And she can take care of her son.
Temporary disability.
But that is for that period still continues, my lord. That is the issued for your lordship. May kindly say 4 years. The certificate is recommended for 4 years, and it was issued only on 23, my lords. And my lord, you also can visualize the intellectual disability person. The student cannot take decision what is right, what is wrong, cannot, my lord. So constant visual is required, my lord.
What is your wife doing? Husband doing?
My husband is also a teacher, my lord.
In that school?
In the same school?
No.
In the
Another school.
In the other school.
Another school. So, my lord, disabled child, it's
No, unless just reading the certificate will not make sense, because what is meant by Down syndrome?
But Down syndrome, you cannot properly understand things, surroundings cannot, what action should be taken, my lord. I have verified from the dictionary, from the net, my lord, what should be proper action. Suppose, my lord, while crossing a road, agile child can see that both the sides of the road, whether many motor vehicle is coming or not. But that decision cannot be taken by intellectual disabled person, my lord. And there is a government guideline under rules of the persons with disability rules, central rules. A guideline has been framed by the government. You also may kindly see. I have, my lord, in my IN number 1545465, I have annexed that guideline, page 32, my lord.
What it says?
That clause 17, posting or transfer of employees with disability. The employees with disability should preferably posted or transferred.
That is employees disability.
That are transferred, my lord. The government employees having children or spouse.
Instruction, my lord. Lordship may kindly have a
Yes, what are your instructions?
I'm waiting. Instruction is, my lord, it is alleged that there was no vacancy of TGT post.
No, that goes now.
That I had
Because that
grounds.
created grounds.
Yeah.
I had 2 grounds. Now I don't press that ground, my lord.
With
Item number 4, come to 4.
Yes. The petitioner has mentioned in a writ petition that her son is reading in class 3 in Bahubandhu Ashram School, having co-education facility. Her husband is now working as headmaster in government SST High School, Girls High School, Bahubandhu. The petitioner had also been transferred to the said high school. Both Ashram School and Government High School are in
the same
village in Bahubandhu, and the petitioner and her husband both are posted to Government SST High School. So the petitioner and her husband has been posted to Government SST High School, Bahubandhu, and Ashram
Can
School.
see that.
Where
Read this first.
her son is reading.
Please give copy to him also.
Yes.
No, husband.
Her husband is there. She has been transferred to the very same school.
Petitioner and her husband posted in so and so.
My lord, husband is in the school where I have been transferred to, my lord. So my question is that since that's a girls' high school, my lord, since that's a girls' high school, I cannot take admission there, my lord. It is only meant for the girls students, my lord. I'm a boy, my lord. That is my ground, my lord. And they have not answered anything in the
Meters away only.
You also may
meters means.
My lordship may kindly see. She can take care of her children.
How?
She can take care of her child.
How if it crosses the road without knowing which bus is coming?
But so far as that place is concerned.
No, not place. You are not catching.
Yes.
You are
Yes, my lord, I'm concerned of that. I'm concerned of that.
We also have children, na?
Yes,
We
yes.
should assume that suppose if my child were to be like that, what I would have done? He is saying, no, because child is not, the certificate is there. The child will not be knowing how to cross the road. That's very important.
Yes,
That is
yes.
the only point. Rest of the things are legal arguments.
Yes, yes.
Out there, we don't give much importance to.
Yes, 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 yes.
So what should be done to that? Mr. G, how he can get the child admitted to the
Girls' High School.
Girls' High School.
Where both the parents are
Yes.
there.
Or can you transfer her husband to that place where child is studying?
If there is, it depends on the vacancy, madam.
Correct.
Lordship may call this matter next week. Let me get that instruction. And it will, because it's a welfare department.
Because the child's interest is involved.
Yes, yes.
And Supreme Court says interest of the child is paramount.
Yes, that is a paramount consideration.
And it has gone to the extent of saying Supreme Court, the courts are parenthetia of
Yes,
children.
yes, yes.
Therefore, it is not just law.
Yes, yes.
Law will not take us anywhere. The justice.
Yes, yes.
You know, one thing I should tell you, when Lord Denning retired,
Yes.
he was called to the court next day. And he called one car and asked the taxi man, take me to the court. The taxi man asked Denning, Court of law or court of justice? Yes.
Well, may I suggest one thing, subject to your lordship's acceptance. Well, if her husband is transferred to that school,
that's what I am thinking.
And I am transferred to that school,
correct.
That girls' high school.
This purpose will be served.
Yes.
Correct. At least mother or father should be there.
Yes, yes.
Just explore that possibility. Yes.
Item 71. It's interim order to continue.
Interim order to continue. Yes. But how? You are already relieved.
She has already been relieved.
Anyway,
in the condition, relief has not been, since I was the headmistress there, my lord, I should have been relieved by the district welfare officer.
Is already relieved.
Welfare officer has relieved me after the order of status quo. That is a record.
Prior to that. Next. Item 71. Sir. Your friend has come.
No, he had come, my lord, but I think his associate is here.
Okay.
Well, on behalf of opposite four in this case, managing committee, conducting advocacy action due to his illness.
But you come all the from Delhi. And that the other day he mentioned it.
I have come 5 times in this matter and gone back, my lord.
How many times he should come and how many times?
One that maybe, kindly one that.
My lord, I am only stating one thing, my lord. Prima facie, if my lord finds that I will bow down to my lord's order that it may be set aside. Concurrent finding, a man Caesar appoints Caesar, my lord. He was the principal of the college who appoints himself, the petitioner. And at one given point of time, he was secretary in charge of the principal, secretary in charge of the principal. This is the man who appoints himself. And concurrent finding, it went back from this honorable court, my lord. The director has made an inquiry, given all details, and stated that the opposite part number 5 was continuing from 2000 and has been continuing till date, my lord. And he was never appointed because he didn't have the qualification in that particular when he was appointed. He had less than 45% marks or something. He takes an examination later, my lord. And it increases, which is hardly permitted, my lord. And he appoints himself. He was the principal of the college when he is appointed. Should, my lord, in this matter interfere in an appeal, my lord? That's my entire submission.
Anyway, your friend also has. Yes, yes, sir. Yes.
This is the case.
Yes.
The respondent number 5 approached the director because this was an audited institution at the relevant time. He approached the director against on the allegation that he was prevented to discharge his duty in the institution, which amounts to termination of his service. And the director passed an order without looking into the fact, because the case of the governing body before the director was, this person was never appointed in the institution. She has produced a fraudulent appointment order, which itself, on the face of the document itself, I'll show it, my lord. It is a fraudulent document only prepared in the connivance with the secretary, because the
who are you?
Private, I am an employee of that institution, subsequently appointed to that post. I have no grievance. So at the relevant time, I have no grievance with that particular post.
According to him, he was appointed on which date?
It was on 15/5/2000.
After OP number?
This is respondent 5.
15/5.
2000, madam. 2000, yes. As a lecturer in Odia. As per the rules.
Okay. 15/5/2000.
Yes. As per the rules.
Sorry. Whether salary is paid by check or money?
No salary to that person, no other document he has filed.
She has only said that this is a fraudulent document. Sir, what is, how your client got the salary?
They used to give sometimes by cash and sometimes otherwise, my lord.
Where is your,
And none of them, none of them are, these are all colleges, my lord, which are not had what that is called grant in aid earlier, my lord. It was running as if it's a private institution, my lord. So whether they are paying me or not is one aspect, my lord. This has been gone into by the director's order, my lord. May kindly see that order.
No, let me place it. How salary to rest of the employees paid?
All of them, my lord, I think in cash. They let my
the institution.
My friend is probably for the institution.
You are for the institution.
I mean, management.
Are you for
For management, opposite core, I will take instruction, kindly take a time.
What instruction? These are the only things which we want to know. Question is whether he is appointed or not. Then to decide whether he is appointed, one of the factors.
But they have no any document, but they never submit any document supporting of their appointment.
No, we are asking you in your timetable, in your salary acquittance register. Where are
We'll produce.
You produce them.
Yes.
And interestingly, my lord, they said I was not working.
Not worry. The appointment itself is wrong. Not
My lord, the director's findings, my lord, may kindly see, and thereafter the appellate committee's finding, my lord, may kindly see.
to the director's case.
No, on what basis?
Made wrong then.
Now they are put in challenge.
Yes, my lord.
Therefore,
No, my lord, what he says is interesting. That someone else was appointed in that post in 2000. That post obviously was not vacant, my lord. Someone was teaching. They said that I was not there. The director makes an inquiry, my lord, and comes to the conclusion that in those very years, he has conducted examinations, my lord. He was a person who was an invigilator.
May be permitted in my own way to place because I am the applicant here.
And thereafter,
my senior, with due respect to him,
two impugned orders.
I asked.
yes, my lord.
I asked.
Yes.
Two impugned orders, my lord.
You produce your bank statement. How salary is paid to everybody.
Yes, ma'am.
All right.
The acquittance rule, my lord, may say that will do.
Acquittance rule.
That
And
other mode.
Attendance register is there.
Yes, madam.
Huh?
Yes.
You produce attendance register, acquittance roll, bank statement.
And my lord, two more things, my lord. Whether that person who is now the petitioner was secretary at the given point of time or not. Two, whether he was principal at the time when his allies were appointed. These are
all the, my lord, entire case of my lord senior is, he want to made out a case on negative equality. Because I am not there, he will get the event. That is not the case.
No, but he is saying that I am not eligible.
Okay, let him produce. I will place.
Number, who are you?
Governing body.
Governing respondent 4.
P number 4 is directed to produce the original documents, namely the acquittance roll,
pay acquittance roll,
comma, the bank statement as to how salary has been paid to other employees.
Yes.
Employees during the period between May 2000
up to date,
up until date. Till date. And what you said, sir? What other document?
Well, I am stating he was the secretary at a given point of time, and he was principal at the given point of time when he was appointed himself.
But the rule says principal comes secretary.
Yes,
one rule.
Yes, my lord. How does he appoint himself, my lord? I'm only stating that.
I have not appointed myself. That is wrong. I'll place. Let the resolution book be placed here.
Yes, let the resolution book be
There is no resolution in support of my lord senior's client. He was not there. He has prepared an appointment order and shown it to everybody.
And the document whereby petitioner has been appointed as the principal.
Yes. No principal. I was appointed as a lecturer. There is no post of principal in private college.
But you were secretary also.
No.
You were in charge.
If he is saying I accelerate, I am asking you. No, my lord. Cannot be.
My lord, can you note this, my lord?
Yes.
Yes.
I was not the secretary.
Yes.
Secretary was some. That name is there. I have given it. I am just waiting.
Somebody else. Let him. The records relating to appointment to the post of secretary and principal. Yes. During the said period.
Yes. And the other person, my lord, was appointed to the same post.
That document is there on the record. That is there. That they will produce it.
And my lord, may kindly call for let the director also give their response.
This is an appeal. What some? On the next date of hearing. All this matter.
Let Malkanagiri to distant place. It may be next month.
Choose a date. But that day you have to produce.
Okay. आज मुझे दोस्तरी
Second week of November.
10th of November?
Second week of November.
That's fine. 10th of November. Monday. Because your senior friend has to come from Delhi, na?
Monday.
Sir, Monday after Friday.
No, I know. Except Monday, Friday.
Okay. 13th? Thursday. Yes. 13th of April. 12. Yes. Okay. Published. All production of these documents will be viewed very seriously, and court may pass order for arrest and detention of the concerned officials of the school. Yes. That's the only way. If one person is arrested, things will happen, everything. From all sections. I am just saying to enforce our orders to just I'm waiting where to put them under behind the bar. I'm just waiting for such cases. Unfortunately, they are not coming. They are ending with high cost, etc. They should go behind the bar. Yes.
Contempt and my lord, because my lord have not passed. My lord's order had not right to file a contempt. Only in the comparison. Many contempts, my lord can do this. Whatever, my lord.
Now it is rapid.
Now some cases are happened, my lord will come in a contempt, my lord will pass.
Just waiting. Yes. Item 72? Yes.
72, my lord, sir. I am appearing for the petitioner. My lord, the notice, my lord, the first three cases, Puri municipality has to be issued with notice because learned senior council has accepted notice on behalf of Puri municipality.
Your Lordship, I am appearing for Puri municipality, Your Lordship. Today only we received the notice, Your Lordship. Today only in the office we received.
Are you from Delhi?
No, Your Lordship, I am from Cuttack only, Your Lordship.
Then why are you from Delhi also people come and argue in this court?
I may be pardoned, Your Lordship. Today only I may be pardoned, Your Lordship. I was there in the court, but due to urgency I had to come.
One thing. So for municipality.
How is your health now?
Mr. Okay.
Fully recovered?
Not fully recovered, sir. All life matters. Things are going on, matter. Fact remains, in this case, whether Puri Monarch Development Authority has jurisdiction to pass afterwards order or not, that is the question. So if it is within coming,
that is covered by Mishra's judgment.
No, madam. So that is
one.
No. That is not. It is relating to unauthorized construction. Unauthorized action taken by PKDA. Our case is very simple. That municipality is not coming within the purview of the municipality, so it is not. Municipality is not required at all because we are going to file counter today. That is what I request. My lord may be taken off some other day so that my lord needs to. In between, municipality files a counter. That's a different thing.
Okay. Shri so and so appears for. You tell which, therefore you should be here. You can. There are so many cases. Which respondent it will be? We will not be knowing at all.
Read petition number 27739 and 27741. We have instructions to appear today, Your Lordship.
In which matter you appear?
Your Lordship, 27739 and 27741 of 2025, Your Lordship.
For OP number 4.
OP number 4. Puri municipality, Your Lordship. Yes, Your Lordship, Puri municipality.
OP municipality, you say that. Which date?
I think I will be filing counter today. I think tomorrow may fix any some date, my lords.
Whichever date you choose.
Maybe my lords on 23rd.
Sorry, my lords, I have some personal difficulty because 2 cases I'll be out of station. May I pray for any date in the second week of November? Because continuously.
Fact remains, one thing. This is Puri. Unauthorized construction aborting seashores. And lot of unauthorized construction ultimately would create a problem so far Puri is concerned. So I pray, my lords, it might be taken because my instruction secretary told me today that these people, they covered it and inside they are undertaking construction, which we cannot control also, in spite of the undertaking even here. So may I pray, my lords, can be taken up some other day so that it can be settled. This 27? 27 will be all right, my lord. 27 all right.
My lord, my lord, 17th, there is an arbitration, my lord. My personal difficulty, my lords, it is fixed. That case is going on Bilaspur. The evidence is open. So from 17th till 20th, continuously, that will continue. Again, I am coming. No, I am coming to that. And again, the subsequent dates, my lord, has been fixed to this 2nd and 3rd. So I have to prepare, my lord. It's a very bulky. So I have some personal difficulty. So all I pray, I will not seek for adjournment. Once they file the response, I will not seek for any adjournment.
On 11.
Yes, my lords.
11. Because 2 days.
I will not seek for any adjournment.
We commencing 3rd, there will be on 3 days only for. So
11th November.
11. So it's all right, no problem. Okay. But only one thing I pray, my lords. Let them ensure that
No, my lords.
to undertake any construction.
From 28
order.
I am coming to that. 28th of last month, since it was brought to my notice, in total there are 5 number of cases. One particular client, because there was some miscommunication from my office, by the time the order reached on 27th, so I was told that there was some carrying the sands and everything and tiles inside the. So I asked them to immediately stop. From 28th onwards, my lord, there is no construction, nothing. Everything has been stopped from 28th.
Everything is stopped there.
With due humility, what they have done is that the secretary told me today itself. They are covering it by cotton.
No, I don't know. Police there.
But
I direct the police.
That is there, my lords. Some retaliatory observation, my lord, that will help, my lords, that will protect them.
The undertaking given by the council appealing for the petitioners that no construction activity would be undertaken is placed on record. First, to ensure that this undertaking is complied with, is not breached, commands. Who is the SP of that concerned?
SP Puri,
the superintendent of police Puri is directed to supervise periodically as to whether any construction is going on. And in the event any construction is being made, then to arrest the violators of this order and produce them before this court on the next date of hearing. Call this matter on 11/11. Okay. Subject order is continued.
My appearance for OP number 4 may be recorded.
Okay.
In all the 5 matters.
In all the matters. Okay. They will be arrested and detained and shall be produced before this court on the next date of hearing. Registry to send a copy of this order to the superintendent of police by speed post and by mail.
I will also get that copy and
so, if this apart, if they do that, on that ground, I will dismiss the petition.
No, ma'am. I have already informed. So I have fairly submitted before Lord.
Yeah, of course.
Because
of that, I made this order. Yes. 73.
May I please, Your Lordship?
My health is not that good today. Somehow time has not come for these matters. I will post these matters in November.
Yes, yes.
Are
yes.
On 10, 12, 30. How many matters are there? So 3, 4, 5. So 10, 12, and 14. Okay.
Yes, particularly in item 75.
These are FAO matters, no? So Thursday they have to come. 13, 11.
13. Item number 75. FAO number 468 of 2024.
468.
Interim order is there. Interim order to continue.
My lord, I am for the appellant number 556 of
FAO number 556 of 2024, for whom my learned friend is appearing. He has not served a copy to us.
I am serving a copy now.
Yes.
My lord, kindly fix a date for final hearing.
Yeah, I have fixed.
My lord,
13, 11. I have fixed already. Interim order to continue. Wherever interim order is there. Yes,
But in the corrected matter, that is 468 of 2024,
Yes.
interim order is there.
The second case is same, man. I am same person.
Same person, two appeals.
Your Lordship, item 74.
74. Which is your matter?
71.
71.
74.
His matter is 17. That's one.
74. I counter affidavit. I have given a copy to the petitioner.
You have given the copy. You take some date, not possible today.
Your Lordship, on the last occasion, this Honorable Court asked me to supply this copy of the order. Yes,
You give copy to them also.
Yeah. Okay. Maybe a short date, Your Lordship.
It will be November 13. The Xerox copy.
No, Your Lordship, that's a certified copy. I have given.
Certified copy.
Yes, Your Lordship. Certified one.
Appears to be color print.
It is already color printed. It's a color printed, Your Lordship. It's color printed. No.
No problem.
So it's certified. There is a certified one.
Certified one.
Yes, sir.
Which there was order? Any order?
Yes, my lord. Previous letter, your lordship directed to produce this copy.
This order. This copy of this order.
Appellant, in terms of order dated 11/9/2025, has produced a copy of the order dated 29/8/2011, made by the State Education Tribunal, Bhubaneswar, in GIA number 6 of 2008.
Yes, sir.
Yes.
71.
Sir, 71.
Sir.
It's adjourned, na? 71, which date you want? Somebody took time in that.
71 is in person, wherein government said. भूल रही थी 71 की अर्जन थी अरे सीधे लोग
that we not sure call this but some other date we shall file a counter
on 20 November.
My lord.
20th November. Pending Korea.
20 November.
20 November. Which date you want?
Tomorrow.
Thankfully, he did not say no only. We have some difficulty. We'll have it on 20th of November. Which place you are coming from? Bhubaneswar. No problem. Yes.